Please, Your Lordship, with the consent of the other side, I beg to mention item number 9, Your Lordship. An adjournment slip has also been given, as Mr. Senior Counsel, Mr. J.N. Sahewala has an appointment for Dr.
Miss
K. Sharma.
K. Sharma. Anybody from the respondent side?
Yes, Lordship, I'm for the response. My senior name may be recorded. P. Gusam.
Okay, Miss Sharma, the learned counsel for the petition has made a prayer for adjournment with the consent from Mr. R.R. Kakoti.
P. Kakoti.
P. Kakoti.
Yes.
Learned counsel representing Mr. B. Usami.
Yes.
Learned Additional Advocate General, Assam. Post of a mentioned memo to that effect has also been circulated yesterday. Post of the above of the matter. The case stands advance for adjourn for
Your Lord-
prayer for adjournment is for what?
Mr. J.N. Sahewala is having.
No, what time?
Oh,
After 2 weeks. Adjourn for 2 weeks. Adjourn for 2 weeks.
Your Lordship, a date may be fixed.
2 weeks.
May I please, Your Lordship? Lordship, I beg to mention item number 10, Lordship. Lordship,
10?
my senior, 10, Lord.
Yes.
Lordship, my senior Mrs. A. Gines suffering from viral fever, Your Lordship.
Okay. A guy
A. Gine, Lordship.
CGC.
This is
Who is for the petitioner? Miss
Medhi.
Land Council for the petition is present. Miss
M. Burman.
M. Borman Land Council on behalf of Miss A. Gayon, Land Central Government Council for the State Union of India respondents has made a prayer for adjournment on the ground that Miss Gayon is indisposed. Post of in view of the ground cited. Raised the case after 2 weeks as sought for an agreed to by the Land Council for the parties.
After a week, Your Lordship. After 1 week.
After 2 weeks, because vacation is coming.
Okay.
My lord, I beg to mention a matter, my lord, for admission hearing, my lord, next week, my lord.
What is the subject matter?
My lord, regarding my lord, NOC for sale of land, my lord.
Okay.
Please, Your Lordship, I beg to mention for listing one WPC for admission, Lordship. This
subject
week,
matter?
if possible.
What is the subject matter?
It's a land matter, Lordship.
Give it to the court must.
Oblige.
Yes, Mr. Roy.
Lordship, with regard to item number 6, Lordship. Here, Lordship, I have not received the instruction. Let it come after next week, Lordship.
What is the,
I have informed the
what is the issue?
issue was, the Panchayat election, Lordship, section 7 petition is pending under section 100.
Section 11
Section 11 petition.
Section 11 is what?
is the regarding madam, allegation with regards to malpractices in my
the
lord
Panchayat election.
in indirect election.
Election of president.
Yes,
vice
yes,
president.
yes,
Lordship.
yes.
That
Just
instruction I am not,
dispose of. Directing the district commissioner to take a decision
Lordship, that can be done.
on section 11 petition.
Lordship.
Yes,
Within a time out time.
Lordship.
yes,
Within 1 month time. Yesterday we have disposed of.
Lordship.
yes,
That can be.
Because he has to take the decision.
yes,
Yes.
yes,
Thereafter you can file a
yes,
petition.
yes, yes.
Lordship.
But we are, because he has not taken any action, that is why we are.
We have disposed of directing them.
Yes, yes,
Lordship.
Directing the district commissioner to take a decision on section 11 petition within a time bound
Lordship,
1 month
Lordship.
after putting all the stakeholders
Yes, yes,
to notice.
yes, madam.
Yes.
After
Yes.
hearing them.
Yes, madam. Fair enough.
My lord, one item, my lord, for admission, municipal no confidence motion, my lord, pending since June. We mentioned to in also,
Next week
yes, my lord, on 9th, my lord,
or next week,
Yeah.
any Monday?
on 8th,
Monday.
8th, my lord.
Supplementary list. Any other request? Supplementary list, items 12 and 13.
What is the first petition? I did not
His Honor,
see the first petition.
the first petition.
What is the subject matter of the first petition?
In the first petition, we are challenging the order of the DC.
DC.
But when the
That was
petition,
not a statutory order.
no, it is not a statutory order. And it
But
wasn't
it
even
was,
acted.
subsequently there were supervening circumstances.
Yes, yes. So I don't think that stands.
Okay. As for the petitions. are preferred by the same petitioner and have raised issues, interconnected with each other, the petitions, both the petitions are taken up together for consideration as at the instance of the Learned Council for the parties. Full stop. In the writ petition, in the writ petition, WPC number 7827/2016. Comma. The petitioners have assailed what is the minute? Impugn minute? Annexure 7.
Actually, 7,
Page
86.
86. Have challenged two of the directions. Two of the actions directed for implementation in a meeting, held on 3/10/2016, in the office of the Deputy Commissioner Kachar, Silchar, in connection with the affairs of the petitioner number 1, Messrs. Bhuban Valley Tea Estate. Poster. As per the impugned instruction, the Deputy Commissioner Kachar, Silchar, within bracket presently District Commissioner Kachar, Silchar, within bracket. He is not even a party.
He's been. Respondent one is the Deputy Commissioner.
Huh?
Respondent one.
Law is settled, Deputy Commissioner cannot represent the state of Assam. Decision to devotion, decision.
In any case, Your Honor, nothing survives in this.
Okay. Directed. No, who is not a party? No, directed. The additional district Deputy Commissioner Revenue to take steps against the management of the tea estate as per rules for failure on the part of the tea estate management and for its non-performance and non-adherence to the conditions against which the parcel of land was leased out to the tea estate by the government. Full stop. The Assistant Labor Commissioner was directed to assist the Additional Deputy Commissioner in page 87, A, formation of a management committee for taking over the affairs of the tea estate till further orders, and B, starting pruning of the tea bushes by November 2016. Full stop. Para. The second writ petition, WPC number 3735. 35 was preferred to assail a certificate dated 9/11/2016, issued by the authorized officer, Board of Trustees, Assam Tea Employees Provident Fund Organization, within bracket ATEPFO. This is Roman 1. 2, Roman 2. A notice of demand dated 18/11/2016, issued to the manager, Messrs. Bhuban Valley Tea Estate by the recovery officer, ATEPFO entry. An order of attachment dated 8/3/2017, issued by the recovery officer, ATPFO. দুইটা লিখিব শিলচৰ জন কাছাৰ। Full stop. Para. The petition number 1, Messrs. Bhuban Valley Tea Co. within bracket P Limited is a private limited company incorporated under the provisions of the Companies Act 1956. And the company was renamed as such pursuant to a fresh certificate of incorporation dated 11/2/2013. Issued by the Register of Companies, West Bengal. Full stop. Para. The petition number 2, is the authorized representative, there's power of attorney of the petition number 1 company. Full stop. The petitioners, for ease of reference, are mentioned herein after. as the petition. Full stop. Para. The case projected by the petitioner in brief, is that by virtue of a deed of transfer dated 31/3/2016, the assets and liabilities of Messrs. Bhuvan Valley Tea Company, which was a partnership firm, was transferred to the petition number 1 company. Full stop. As a result, the tea estate in the name and style of what is Messrs. Bhuvan Valley Tea Estate.
Yes, sir.
Bhuvan Valley Tea Estate. Along with the parcels of land assets and liabilities of so and so, along with the parcels of land were transferred to the petition number 1 company. Full stop. It may be stated that the tea estate faced a number of difficulties and disturbances during the previous years. Full stop. There were hesitations by the laborers and the laborers stopped working in some periods during the year 2016, which halted the day-to-day, which affected the day-to-day affairs of the tea estate as well as the petitioner. Full stop. The petitioner. The management also faced financial difficulties and after a discussion with the district administration, a petitioner executed a bond on 31/12/2015, giving an undertaking before the district administration to pay the government dues in 60 installments within a period of 5 years. Full stop. A series of meetings were held with the district, between the petitioner and the district administration, Kamakachar, and it led to a series of directions, a series of instructions, led to issuance of a series of instructions in the meeting held on 3/10/2016. Full stop. The instructions which are impugned in this, in the writ petition WPC number 7827/2016 are briefly mentioned here in above. Have already been mentioned briefly here in above. Full stop. Para. During the subsistence of the bond executed on 31/12/2015, the authorized officer ATPFO issued a certificate to the recovery officer ATPFO Silchar Zone on 9/11/2016, certifying that a sum of rupees 1,25,98,226.78, page 119, was due from the petitioner company towards arrears provident fund contribution stroke provident fund administrative cost. What is DLI? Deposit link insurance. Deposit link insurance. DLI contribution stroke DLI administration cost, along with 15% statutory interest stroke levy of damage payable under the Assam Tea Plantations Provident Fund and Pension Fund Linked Insurance Fund Scheme Act 1955, within bracket 1955 Act or the Act 1955. Full stop. Immediately after issuance of the certificate dated 9/11/2016, comma, the recovery officer ATPFO Silchorjon Kachar, within bracket. Response number 6. Issued a demand notice on 18/11/2016 to the petitioner in reference to the certificate dated 9/11/2016. Full stop. By the notice of demand, comma, the petitioner was informed that the authorized officer, Board of Trustees, ATPFO, had issued a certificate for recovery of the sum of rupees 1,25 lakhs so and so. Full stop. By enclosing a statement as Annexure A with a breakup of arrear amounts payable under different heads, comma, the petitioner was asked to pay the said amount within a period of 15 days from the date of receipt of the notice of demand. Full stop. It was further informed that in case of failure to deposit the said dues, comma, steps should be taken for the recovery of the said amount as per the provisions of Section 15B to Section 15G of the Act 1955. Full stop. It was further mentioned that in addition to the sum of rupees 1 crore so and so, the petitioner would also be liable to pay interest in terms of Section 11A of the Act 1955 for the period of default in depositing the arrear dues till the date of actual deposit, and all costs, comma, charges and expenses incurred by the ATPFO authorities. Full stop. As the petitioner failed to clear the arrear dues within the required period of time, comma, the respondent number 6 issued the impugn order of attachment of immovable property on 8/3/2017. Full stop. Order of attachment was stated to be issued in exercise of powers conferred on respondent number 6 under section 15B of the Act 1955. And the respondent number 6 had prohibited and restrained the petitioner to deal further with the property mentioned in the said notice of demand. Full stop. It was further mentioned that Income Tax Act. One of section 222. And restrictions imposed would be in reference to the explanation to subsection 1 of section 222 of the Income Tax Act 1961. Full stop. The specification of the properties indicated in the order of attachment included 3 divisions of the tea estate, namely 1 North Bank Division, 2 Bhuvanbeli Division, Motinagar, and 3 Singur Division. Full stop. Para. I have heard Mr. B. Das learned counsel for the petitioner. Mr. N.C. Das, senior counsel, listed by Ms. M. Debi. M. Debi. Learned counsel for the respondent ATEPFO authorities. Mr. S.S. Roy, learned junior government advocate Assam for the state respondents. And Ms. G. Goswami, learned counsel for the respondents number 7 in WPC number 3735/2027, 2017. Full stop. Para. Mr. Das, learned counsel, appearing for the petitioner, has submitted that when the writ petition, WBC number 7827/2016 was preferred and moved. Comma, on 8/3/2017. Comma, it was observed that it was submitted by the Telangana State Council that no adverse consequences would follow. Full stop. Yet, comma, the respondents ATPFO authorities had proceeded to take steps under the provisions of the Act 2015.
Look, just I'm pointing out, my lord, this action is initiated as per the amended provisions of the Act, my lord.
Huh?
As per the amended provisions of the Act, my lord.
Huh.
The Act was amended in
As
2016. my
per
lord.
the provisions of the Act 1955, comma, as amended,
In 2016, my lord.
as amended in 2016. Full stop. He has further submitted that something you refer to certificate proceeding rules?
Yes, sir.
Which one?
That the attachment was under 61, 70 and not 69.
No, from this book, you referred to certain provisions yesterday.
Yes, sir. So first I had referred to was rule number 52.
52. Yes, yes. He has further submitted that along with on the same day, the order of attachment of immovable property was made. That is on 8/3/2017, comma, the ATPFO authorities had appointed the respondent number 7 in WPC number 7 T7T5 as the receiver purportedly in terms of the explanation to subsection 2 of section 222 of the Income Tax Act 1961. Full stop. It is his contention that a receiver so appointed has to act as per has to be made as per rule 52 of the income tax within bracket certificate proceedings bracket close rules 1962. Full stop. But the receivers who appointed had exceeded his powers during the subsequent period, thereby making the impugn actions on the part of the ATPFO authorities bad and illegal. Full stop. He has further submitted that the receivers who appointed had continued to manage the properties of the petitioner, business of the petitioner since his appointment on 8/3/2017 till date. Full stop. He has further contended that the default, the arrear dues to the ATPFO authorities were only 1 crore 25 lakh something. And the receiver and the ATPFO authorities have continued the arrangement first for a period of 7 years and thereafter giving it a new lease, giving a new lease to the arrangement, for a further period of
12 years.
12 years.
12 years.
On which year?
2024.
2024.
No.
2024. Full stop. The aforesaid actions were not fair and against the object and purpose of appointing a receiver. Full stop. He has submitted that the duties of a receiver have been laid down in Rule 50 of the Income Tax within bracket certificate proceedings. Rules 1962, whereby he is obligated to submit his accounts regularly in the prescribed manner. Full stop. He has submitted that the petitioner during all these years are kept in dark about the accounts submitted by the receivers. It is for your subsequent action, not for this. Mr. Das Lanet, Senior Counsel appearing for the respondent ATPFO authority, have submitted that it is an admitted position that the petitioner company stroke estate had defaulted consistently during the previous years in depositing the statutory dues under the Act 1955, and the same led to the issuance of the certificate on 9/11/2016. Full stop. The arrear statutory dues, including PF dues of the laborers of the estate rose up to 1,25,98,000 to 26.78 as on the date of issuance of the certificate, and the authorities acting under the Act 1955 had to resort to the certificate proceeding for recovery of the said amount, as the petitioner failed to deposit the demanded amount, comma, the order of attachment had to be issued on 8/3/2017. Full stop. He has further submitted that as the petitioner had a tea estate, comma, the ATPFO authorities had to appoint a receiver in order to realize the arrear amounts as well as to manage and preserve the properties or attached property, and to collect the rents and profits thereof. Full stop. Means as the arrear dues were could not be realized within a period of 7 years, comma, a fresh deed of agreement had to be entered into with the receiver for a further period of 12 years on 13/9/2024. Post of MS, post of as such, comma, no interference is called for to the impugned certificate, comma, demand of notice and the order of attachment. Full stop. It is submitted by Mr. Das that a writ petition is to be decided on the basis of challenge and the fact situation obtaining on the date of referring the writ petition. Full stop. The subsequent full stop. He has submitted that the subsequent actions, comma, which have been agitated by on behalf of the petitioner have no bearing on the impugned certificate, comma, the certificate, comma, the recovery notice and the order of demand. Sorry, what is the name? Notice of demand. Impugned hearing. Full stop. Ms. Goswami, Pera, learned counsel, appearing for the petitioner, respondent number 7 in WPC number 3735/2000, 2017 has submitted that after being appointed as a receiver on 8/3/2017, in terms of Rule 70 of the second schedule to the Income Tax Act 1961, comma, due and proper accounts of all the receipts and disbursements were maintained by the receiver. Full stop. Initially, a deed of agreement was executed between the ATPFO and ATPFO through the recovery officer and respondent number 7 that's receiver on 6/4/2017 for a period of 7 years, comma, subject to renewal, comma, on terms and conditions mutually agreed upon by the parties. Full stop. On taking over possession of the tea estate as receiver, the receiver had sincerely undertaken all the efforts to make payment of the certificate amount of rupees 1,25,00,000 so and so, and also the statutory interest thereon for delay. Full stop. MS Goswami has submitted that in turning the Sikh garden into an operational one, the respondent number 7 had to invest a huge amount of money, and at the same time, comma, to clear the statutory dues. Full stop. Upon successful completion of the first term of lease of 7 years, comma, ATPFO authorities, after being satisfied with the performance of the receiver and discharge of responsibilities, comma, had renewed and extended the period by executing a deed of agreement again on 13/9/2024 for a further period of 12 years. Full stop. MS Goswami has submitted that the respondent number 7 had invested an amount of rupees 1,23,07,947.77 for restoration of the tea, in making the tea estate operational, and also paid the certificate amount. Full stop.
It should be recovery certificate, my lord. Recovery
Principal
certificate.
amount.
Right.
Mentioned in the certificate.
Right.
Principal amount rupees 1%. Full stop. And in addition to the said in principal amount, comma, further amounts are to be paid towards statutory interest
Interest, ma'am.
and other dues. Full stop. Anything, miss? This is the fact, this is the fact? Oh, full stop. Huh?
Yes.
Ah. Ah. It is further submitted that thereafter the receiver had invested further amounts and a and proper accounts are being maintained and the same are submitted to the ATPFO authorities from time to time for their information and necessary action. First of para. Reverting back to the reverting back to the facts of the case, comma, it is found to be an admitted position that the petitioner defaulted in depositing the PF contributions and PF contributions, DLI contributions, ETC, etc. to the ATPFO authorities. Full stop. Para. The Assam Tea Plantation Provident Fund and Pension Fund and Deposit Linked Insurance Fund Scheme Act 1955, within bracket, 1955, is an act which has made provision for framing of a compulsory provident fund and pension fund and deposit linked insurance fund scheme for employees employed in tea plantation in Assam. Full stop. The employer as per the act, employer means a person who is a proprietor of a plantation and including a managing agent, like a proprietor of a plantation. And employees means any person who is employed to do any skilled or unskilled, manual or clerical work in connection with a plantation. Full stop. The contributions to be paid by the employer to the provident fund and pension fund and insurance fund scheme are compulsory. Full stop. The act was amended in the year 2016. Certain provisions of the Act 1955 were amended by the Assam Tea Plantation by an amendment act in 2016. Full stop. The Amendment Act inter alia substituted Section 5, which has the nominal heading recovery of money due from employer. Full stop. The substituted Section 5 reads as under. Huh? Full stop. The manner and procedure of recovery of monies have been laid down in newly inserted Section 15A to 15G. Full stop. Subsection 1 of Section 15B has prescribed that wherein any amount is in arrear under Section 15, the authorized officer may issue, to the recovery officer, a certificate under his signature specifying the amount of arrears, and the recovery officer, on receipt of such certificate, shall proceed to recover the amount specified therein from the plantation, or, as the case may be, the employer by any one or more of the modes mentioned therein. Therein, A, B, C. The first proviso to subsection. Okay, there is no sale involved. No sale involved.
No.
Whereas subsection 1 of Section 15D has set forth that when the authorized officer issues a certificate to a recovery officer under Section 15B, it shall not be open to the employer to dispute before the recovery officer the correctness of the amount or any other materials in the certificate, and no objection to the certificate on any ground whatsoever shall be entertained by the recovery officer. By Section 15G, certain provisions of the Income Tax Act have been made applicable to the Act 1955. Full stop. The provisions of the second and third schedule of the Income Tax Act 1961 and the Income Tax Certificate certificate proceeding close rules, 1962, as in force from time to time, shall apply, are made applicable, with such modifications as may be necessary for their application to the Act 1955, as if the said provisions and the rules are referred to the arrears of the amount mentioned in Section 15 of the Act 1955 instead of the income tax. Full stop. The provision to Section 15G has provided that any reference in the said provisions of the Income Tax Act 1961 and the rules to the word within bracket SSE unquote shall be construed as a reference to an employer as defined in the 1955 Act. Full stop. Para. When the admitted position of default to the tune of rupees 1 crore so and so is considered against the actions taken by the respondent ATPO authorities in issuing the certificate dated 9/11/2016, the notice of demand dated 18/11/2016, and the order of attachment dated 8/3/2017 are considered, it is found that the actions taken by the respondent authorities in taking such steps through the certificate, the notice of demand and the order of attachment are in conformity with the provisions of section 15, section 15B within bracket 1 section 15D1 of the Act 1955. Full stop. In view of the admitted position as regards default made by the petitioner towards contribution to the provident fund, pension fund, insurance fund, as maintained by the ATPFO authorities, as per the statutory prescriptions of the 1955 Act, no interference is called for. Full stop. Para. Before that, cycle stop. The in sort of stop. In the Mr. Das Land Council, paying for the petitioner, has fairly submitted that in view of the subsequent actions taken by the respondent ATPFO authorities, the relief sought for in the first state petition, WPC number 7827/2016, had virtually rendered infructuous. So stop. Para. In the subsequent repetition, in the second repetition, the petitioner is found to have assailed the certificate dated 9/11/2016, notice of demand dated 18/11/2016, and the order of attachment dated 8/3/2017. Full stop. Para. Full stop. But no challenge is made to the appointment of receiver by the recovery officer, respondent number 6, on 8/3/2017. Full stop. It is submitted by Mr. Das that on 8/3/2017, when the writ petition WPC number P735 was preferred, the petitioner was in dark about the appointment of receiver by the respondent number 6 on 8/3/2017. Full stop. He has submitted that it was only after filing of the affidavit in opposition by the respondent number 4, 5, and 6 in WPC number 3735/2017, the petitioner came to learn about the appointment of the petitioner or receiver and or appointment of the petition receiver. Full stop. And it was the appointment of the, it is the appointment of the petitioner and the steps taken, steps and actions taken by the ATPFO authorities and the receiver, which are brought through the affidavit in reply filed by the petitioner in these writ proceedings. Full stop. He has submitted that in order to for deciding the writ petition, such subsequent actions taken by the ATPFO authorities and the receivers are required to be taken into consideration to adjust on their actions. Full stop. Para. Though it is contended, though it is submitted on behalf of the petitioner, that the petitioner had no knowledge about the appointment of the receiver on 8/7/2017, it is noticed that the respondent number 4, 5, and 6 in their affidavit in opposition, filed on 16/11/2017, had annexed the order of appointment of the receiver, order of appointment, date of appointment of the receiver, which was made by the respondent number 6 on 8/7/2017. Full stop. Where did you find your reply?
It came by way of an additional affidavit, Your
When?
we dated 2011-2023.
Despite having the knowledge of the appointment of the receiver as far back as on 16/11/2017, the petitioner had filed an additional affidavit only on 21/11/2023. Which paragraph?
His Honor.
Which paragraph? Stating inter alia that the conduct of a receiver had to be strictly as per the provisions of the second schedule to the Income Tax Act and the and a receiver is duty bound to keep proper and accurate accounts and an inventory of all assets and to submit it for its submission to the appointing authority from time to time. Full stop. It is contended therein that some selling price you said, right?
Yes, sir.
The
selling
average
price of the
selling
tea.
price
Now
of
that-
tea.
That comes from the R7's counter affidavit.
Oh, you said something?
Yes, but the tea has been sold at
Ah.
depressed price, sir.
Less price. Less than the market price.
Yes.
It is, the petitioner has sought to contend that the receiver appeared to have sold the tea at a lesser price than the average price. And such actions are not in tune with the duties and responsibilities of a receiver appointed as per the statutory provisions. Full stop. Para. আপনাদের এই যে লাস্ট প্রেসিডেন্ট do not call for interference. Full stop. In the affidavit in opposition of the respondent number 7 gas receiver, it has been stated that after the agreement dated 6/4/2017, it made huge investment to the extent of rupees 11 crore, to the extent of more than 11 crores till date. Full stop. Upon taking possession of the tea estate in 2017, the respondent number 7 paid the certificate amount of rupees 1,25,98,226.78 and certain other pending areas, gratuity, etc. to the ATPFO. Full stop. The deed of agreements dated What is the date of the agreement? First one? 6/4/2017. And next one? 13/9/2024. Are made, have been made part of its affidavit in opposition. Full stop. Para. This court on three ten 2024 had asked the respondent ATPFO authorities to place on record as to how the amount received from the receiver were being adjusted against the dues of the petitioner and the basis thereof. Full stop. In addition, respondent ATPFO authorities were also asked to bring on record an inventory which was prepared at the time when the tea estate was handed over to the receiver. Full stop. When it was filed?
Would have been filed on 5/11/2024.
5/11/2024. It runs from which page?
Run from page 171.
1 second. In reference to the order dated 3/10/2024, an additional affidavit on behalf of the respondent number 4, 5, and 6 was filed on 5/11/2024. Wherein it is stated that pursuant to the deed of agreement, the receivers who appointed, deposited an amount of rupees 1 crore 6,06,872 against the recovery certificate amount of rupees 1 crore 25,98,226.79. And as a result, there remained a balance of rupees 19,91,354.79, which was not deposited by the receiver till that date. Full stop. It has been further averred that apart from the balance amount of rupees 19,95,354.79, statutory interest at 15% has to be computed upon deposit of the entire certificate amount, entire recovery certificate dues. And the same would be recoverable from the receiver Closed. The Mr. Das, Senior Counsel, has submitted that it is a stand of the ATPFO authorities that as on date, the entire recoverable amount have not been recovered from the receiver. And in view of such non-recovery, the ATPFO authorities had to enter into the
It
the
has been-
arrangement with the receiver for a further period of 12 years on 13/9/2000. Stop. We should hit before putting in the 15B, 15B, insofar আগৰ পৰা মানে আনি পেলাই সেইখিনি দিব এক টনৰ কথা কৈছিলো যে এনে আনি তাৰপিছত দিম insofar as the submission regarding appointment of the receiver on 8/7/2017 is concerned, it cannot be comprehended that the petitioner being the owner of the tea estate had no knowledge as regards appointment of the receiver by the ATPFO authorities who was as the receiver apart from as the receiver has been was appointed to manage has been appointed with the task of management of the tea estate right after his appointment. In any view of the matter, the petitioner was aware of the appointment of the receiver at least from (16/11/2017) onwards. Stop. The petitioner had raised questions about the activities of the receiver only in its additional affidavit filed on 21/11/2023. Stop. Parada law is settled that the rights of the parties must be determined I come back. Maybe like this. It is a normal rule that in any litigation, the rights and obligations of the parties are adjudicated upon as they obtain at the commencement of the lease. Full stop. Any subsequent developments can be taken into consideration to accord relief to the parties provided only when such developments has a material impact on those rights and liabilities, obligations. Full stop. Rights and obligations and bearing on the entitlement of the parties to relief. Full stop. In other words, an action must be tried in all its stages on the cause of action as it existed at the commencement of an action, full stop. When viewed from such perspective, and a challenge made in this writ petition, challenges made in this writ petition to the certificate dated so-and-so, notice of demand dated so-and-so, and order of attachment dated so-and-so, vis-a-vis the order of appointment dated 8/3/2017, the deed of agreements executed between the ATPFO authorities and the receiver on so-and-so and so-and-so, and the subsequent steps, actions, and measures taken on that basis have no material impact and bearing on the actions taken by the ATPFO authorities to the certificate dated so-and-so, notice of demand dated so-and-so, and the order of attachment dated so-and-so, full stop. The order of appointment, no, full stop. Para. The powers of a receiver and his duties are laid down in Rule 48 and Rule 50 of the Income Tax Certificate Proceedings Rules 1962. So as per Rule 48, a receiver appointed has powers for realization, management, protection and preservation of the property, the collection of the rents and profits thereof, the application and disposal of such rents and profits, and the execution of the documents as the owner himself has, and such of those powers as the recovery officer thinks fit. Full stop. A receiver is, however, has a duty rule 50 আছে, under rule 50, comma ABCD. The steps and measures taken by the receiver and the ATPFO authorities subsequent to his appointment dated 8/7/2017 may be causes of action for the petitioner in a separate and independent proceeding, but the same cannot be said to have any material bearing or impact on the certificate dated so and so, notice of demand dated so and so, and the order of attachment dated so and so, which are found to be in conformity with the provisions of section 15, section 15B, and section 15D, one of the Act 1955 as amended. Full stop. Para. In the light of the discussion made above and for the regions assigned therein, comma, this court does not find any merit in the challenges made in the writ petition WPC number 3735/2025 and the relief sought for, and therefore, comma, the relief sought for cannot be granted. Consequently, the writ petition WPC number so and so is found to be bereft of any merits, full stop. In view of the actions taken by the ATPFO authorities, comma, the action impugned in the writ petition WPC number 7827/2017 were found to have been superseded by the actions taken by the ATPFO authorities under the statutory prescriptions of the Act 1955 as amended. And the writ petition WPC number 78/2017 16 is not required to be adjudicated upon as it has been rendered infructuous. Full stop. Accordingly, both the writ petitions are dismissed. There shall, however, be no order as to. So I have left it off. It is up to you.
Obliged, obliged.
Deeply obliged, yeah.
Anything, anything left?
No, my lord. Everything is covered, my lord.
Deeply obliged.
Okay. In view of the order passed today in so and so, interlocutory application is already disposed of.
Item number 14.
Kettle,
Mine.
who is the, yes, Mr. Roy. Anything in defense?
Lordship, only to maintain the peace and tranquility to this, that it was seized, and it was temporary. Lordship, it was temporary, Lordship, because it was
There
temporary.
is a source of power.
There is no,
Huh?
just to maintain the peace, Lordship.
For that purpose, it may be. What is the offense? Nature of offense?
selling,
Non-bailable.
Non-bailable.
none,
You should have been arrested.
Lordship.
That is not done. Oh, Kettle निकलो हम ऐसे. Yes, Mr. Roy. Which item, for which item you are waiting?
One.
One. Okay. Let me finish this one.
Take time, my lord, that's a.
One,
What happened, my lord? We have credit for betting. And to immediate and delete. Come back.
wife. Wife.
No, no,
The petitioner is the wife.
petitioner's wife, my lord. Let it be, my lord, after vacation, my lord.
You are enjoying interim. Otherwise, you would not have said so. Okay, notice estate. Yes, Mr. Thor. Your additional affidavit.
We want some two documents, my lord.
New documents. I have already said, if does not have material bearing, it has to be decided on the basis of facts existing on the date of challenge.
The matter may have become structured. Why I was a deal.
Okay, Mr. Roy, learned senior counsel listed by Miss
B. Shaha.
B. Shaha, learned counsel for the petition is present. Mr. Ardhor, learned standing counsel, enforcement directorate for the respondents has submitted that certain subsequent events are required to be brought on record and the additional affidavit, in deference to the order dated 28/10/2025, has already been prepared and sent for vetting. Full stop. He has thus submitted that the case be listed after 3 weeks then, 3 weeks, in order to file the said additional affidavit within such time. Full stop. The prayer is allowed or release the case after 3 weeks. Okay. 3 weeks, it will go beyond that. After 3 weeks, did 2 weeks by the office. The interim order passed earlier shall continue till the next. Guru. Yes, do you have any power under the Cattle Preservation Act?
For seizing, not lordship.
Huh?
Not say.
Seizure.
See,
And under the
seizure.
Open Establishment Act, do you have any power?
No, man.
No. I heard Mr. J. Loskar, the counsel for the petitioner, and Mr. S.S. Roy. Learned Junior Government Advocate Osam for all the respondents. Full stop. What is impugned here?
My lord, last page 19, my. Connection.
An action on the part of the respondent number 3 in sealing SEALING of the SOP of the petitioner has been assailed in this petition preferred under Article 226 of the Constitution of India. Full stop. Para. The petitioner a businessman by profession, is the provider of Messrs. Sarimul Enterprise and he runs a business of selling buffalo meat, raw meat, chicken, dairy products, page 11, from a shop located at Algapur Bazaar, Algapur, district Hailakandi. Full stop. For the purpose of running his business, such business, from the shop, the petitioner applied for a license and a certificate from the appropriate authorities. Full stop. The which is this Hailakandi Municipal Board. The Hailakandi Municipal Board had issued a license on 4/2/2025 with validity up to 31/3/2026 in favor of the petitioner to run his business. Full stop. A certificate of registration in Form Q was also issued to the petitioner by the Inspector of Shops and Establishment, jurisdictional, under the provisions of the Assam Shop and Establishment Act and the rules 1971 as amended, and the rules framed thereunder, certifying that allowing the petitioner to run the business of selling buffalo meat, raw meat, chicken, and dairy products. Full stop. The certificate of validity, certificate of registration had validity up to 2/2/2026. Full stop. Para. Who is the informant? Lordship, the OC is then. A first information report, FIR.
Page 70.
Came to be lodged. Yeah. By a sub-inspector of police of Algapur Police Station before the officer in charge, Algapur Police Station, on 1/7/2025. Alleging, stating inter alia that based on credible information and subsequent local inquiry, it came to light that certain individuals from the locality of Algapur Bajar were found engaged in activities in violation of the provisions of the Assam Cattle Preservation Act 2021 and the rules framed there under. Full stop. The individuals were found selling beef by openly displaying beef-based item in public. Full stop. On the basis of information received, which was registered as Algapur Police Station General Diary entry number 10, dated 1/7/2025, comma, a team of police personnel from Algapur Police Station conducted a search operation at the shop of Messrs. Sarimul Enterprise, situate at Algapur Bajar, full stop. During search, comma, recovery and seizure of 4 kgs of raw meat weighing 4 kg, 4.5 kg, 4.5 kg raw meat, comma, suspected to be beef, comma, weighing 4.5 kg was made from, as it was found, stored in a refrigerator inside the shop, full stop, by a seizure list prepared at the spot, comma, the raw meat weighing 4.5 kg, comma, a refrigerator and an electronic weighing machine supposed to be used in a business were seized in presence of independent witnesses. Full stop. The seized raw meat was properly sealed and packaged. It was mentioned that the sealed, the seized raw meat was properly sealed and packed. Full stop. The affair further alleged that illegal cattle slaughter was done by the petitioner comma, that is the owner of Messrs. Sarimul Enterprise, along with others, and he was suspected to be involved in the activities of selling raw meat from his shop. Full stop. The officer in charge, Algapur Police Station, was thereby requested to register the affair under the appropriate provisions of the Assam Cattle Preservation Act 2021 and the Bharatiya Nyaya Honita BNSS 2023 and other applicable laws for initiating a thorough investigation into the matter. Full stop. Para. On receipt of the affair, comma, the officer in charge, Algapur Police Station, registered as Algapur Police Station case number 38/2025 for the offences under section 325 within stroke 3 within bracket 5 of the BNS read with section 13 within bracket 1 of the Assam Cattle Preservation Act 2021 and entrusted the investigation to a sub-inspector of police attached to Algapur Police Station. It will be on 1/7/2025. Full stop. Para. Which page you said? Impugn?
Impugn page 19, man.
19.
Prior to this is notice issued by the IOMI.
Okay. Oh, action of sealing will go, no? They said DNA, no? Subsequent to the registration of the FIR on 1/7/2025, comma. No. Blah, 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 blah. No. As seizure was made of 4.5 kgs of raw meat, comma, suspected to be beef, comma, on 1/7/2024 from a refrigerator kept inside the shop of the petitioner, comma, the proprietor of Messrs.
My lord,
Sarimul,
sorry to interrupt, my lord, it should go 5, man.
huh?
2025, not 20.
Huh?
2025.
Oh, it is wrong then. Page 18 wrongly mentioned.
My lord.
Okay. 2025 also, huh? Suspected to be brief, comma, from a refrigerator kept inside the shop of the petitioner, comma, Messrs. Shop of the petitioner, comma, the proprietor of Messrs. Sarimul Enterprise. Allegedly, without any valid license, stroke authorization under the Assam Cattle Preservation Act 2021. And in view of registration of Algapur Police Station case number 38/2025, comma, the IO made a request to the respondent number 3 on 10/7/2025 to seal the shop of the petitioner. Full stop. It is the officer in charge, Algapur Police Station, also wrote to the respondent number 3 on 10/7/2025 comma, reiterating the same facts, comma, to issue necessary orders for immediate sealing of the shop of the petitioner, comma, Messrs. Sami, of the petitioner, located at Algapur Bazar, till the investigation of the case, till conclusion of completion of investigation of the case. Full stop. Para. It was in reference to the aforementioned two letters, comma, dated 10/7/2025, comma, the respond number 3 had passed an order on 10/7/2025 directing immediate sealing. Some more hotel, one more hotel is there.
One more hotel is.
Immediate sealing of the shop of the petitioner located at Algapur Bazar, as the affairs were found, were allegedly found to be conducted in violation of the provisions of the Assam Cattle Preservation Act 2021. Post. In the order directed to the officer in charge, Algapur Police Station, within bracket the respond number 4, comma, the respond number 3 directed that the sealing operation shall be carried out in his presence. Full stop. Accordingly, on 10/7/2000 at 5:30 p.m. on 10/7/2025, comma, the shop of the petitioner run under the aegis, AEGIS, of Messrs. Sarimul Enterprise, comma, at Algapur Bazar, was sealed in connection with Algapur Police Station case number 38/2025 in presence of the respond number 3, comma, the respond number 4, and the IO of the case, and in presence of independent witnesses. Post stop. Para. It is the sealing of the shop of the petitioner, which is assailed. It is submitted that since 10/7/2025, comma, the shop of the petitioner is in sealed condition till date. Full stop. Mr. Loskor, learned counsel for the petitioner, has submitted that the sealing of the shop of the petitioner is beyond the power authority and jurisdiction of the respondent authorities, as no power has been vested on the respondent authorities, more particularly on the respondent number 3 and the respondent number 4, to seal a shop in the course of investigation of the case, which has been registered for violating the provisions of the Assam Cattle Preservation Act 2021 as amended. Full stop. Par contra, Mr. Roy, Land Council, one junior government advocate appearing for the state respondents, has submitted that the activities run by the petitioner from his shop at Algapur Bazaar was clearly an act in violation of the provisions of the Assam Cattle Preservation Act, and the same had posed and gave rise to a possibility of disturbing the public order and communal harmony. Full stop. He has submitted that as per Section 8 of the Assam Cattle Preservation Act 2021, selling of beef is prohibited within areas within a specific distance of from a religious place. Full stop. Para. Section 8, no? Section 8. The Assam Cattle Preservation Act 2021 has been enacted in order to provide for the preservation of cattle by regulating their slaughter, consumption, illegal transportation, and matters connected and incidental therewith. Full stop. Section 3, within bracket B, as per section 3, quote unquote, beef means flesh of cattle in any form whose slaughter is prohibited under the Act. Full stop. Section 8. Has laid down that has placed a prohibition on the sale of beef and beef products. Full stop. As per Section 8, so and so, Para. Section 13 has provided for penalties. Full stop. As per subsection 1, whoever subsection 1 of Section 13, whoever contravenes. Quote kori dibo. Subsection 2 of Section 13 has provided that Section 14 is with a non-obstante clause. And it has been prescribed that all offences under the Assam Cattle Preservation Act 2021 as amended shall be cognizable and non-bailable. Full stop. Para. It is the petitioner on the allegation that he had contravened the provisions of section 8 has been made and accused in Algapur police station case number so and so, registered for the offences under section
13(1).
repeat করে দিব। Para. In the affidavit filed by the respondent number 3, the respondent number 3 has taken a stand that on receipt of the letter dated 10/7/2025 from the respondent number 4, in connection with Algapur police station case number 38/2025, regarding issuance of necessary order for immediate sealing of the shop of Messrs. Sarimul Enterprise located at Algapur Bazaar until completion of the investigation, he issued a letter to the respondent number 4 on 10/7/2025 to carry out the sealing operation on 10/7/2025 in his presence. Full stop. It is further mentioned that apart from the offences under section 325/3 BNS and section 13 of the Assam Cattle Preservation Act 2021, the offence under section 196 B BNSS was added, and therefore, the sealing of the shop was necessitated. Full stop. Para. The power to enter, inspect, search, seizure, and detain have been provided to the authorities mentioned therein in section 11 of the Assam Cattle Preservation Act. Full stop. Para. Rule 9 of the Assam Cattle Preservation Rules 2022, framed in exercise of the powers conferred by section 22 of the Assam Cattle Preservation Act 2021, as amended, has stated that for the purposes of section 8, the intended citizens shall apply for license for beef shop in the prescribed format to the jurisdictional circle officer to the district magistrate of the district. Full stop. The circle officer on verification of the details mentioned in the application shall submit a report clearly indicating that the proposed place of beef shop is not situated in such area or areas which are predominantly inhabited by the communities mentioned therein or within a radius of 5 kilometers of any religious institutions belonging to the communities, religious institutions of the nature belonging to of the nature mentioned therein, belonging to the communities mentioned therein. Full stop. The district magistrate, on application of the on receipt of the application can verify the area and if satisfied, can issue a license for a beef shop in prescribed form. Full stop. The license so issued has a validity of 3 years with renewal facility after every 3 years. Full stop. Para. Admittedly, the petitioner has registered his shop for the purpose of selling buffalo meat, raw meat, chicken, and dairy products under the Assam Shops and Establishment Act, 1971, and does not have a license under Section 8 of the Assam Cattle Preservation Act, read with Rule 9 of the Assam Cattle Preservation Rules 2021. If the seized raw meat, suspected to be beef, is found out to be beef, then only then the petitioner can be charge sheeted. In connection with Algapur Police Station so and so, subject to collection of privacy evidence. Full stop. Para. The question raised herein is whether under the provisions of the Assam Cattle Preservation Act and the Assam Cattle Preservation Rules 2022, the authority any authority who exercises powers under the Act and the rules can seal a shop and continue to keep a shop under seal condition thereafter. To stop the power. To other portion, the power to enter, inspect, search, seizure, and detain have been set out in Section 11 of the Assam Cattle Preservation Act. Short form as amended. For the purpose of enforcing the provisions of the Act, a police officer not below the rank of a sub-inspector or a registered veterinary officer or any person authorized in that behalf by the state government shall have the power to enter and inspect any premises within the local limits of jurisdiction of such persons where he has reason to believe that an offense under the Act has been or is likely to be committed. Every person in occupation of such premises is required to allow the police officer or the other empowered officials such access to the premise as he may require for the aforesaid purpose, and shall answer any question put to him by any police officer of such rank or any other empowered officer to the best of his knowledge and belief. Full stop. A police officer of the rank of sub-inspector, not below the rank of sub-inspector, or the other empowered official, if of the opinion that an offense under the act has been committed or is likely to be committed, may seize any material or carcasses or cattle or vehicle or conveyance, which have been or likely to be used in the commission of the offenses, from the premises so inspected, and may detain any person suspected to have committed such offense. After the seizure, such police officer shall report such seizure without unreasonable delay, before the judicial magistrate first class. And the police officer or the seizing official shall maintain the seized cattle. On receipt of a report, the judicial magistrate may, on his being satisfied, that there is enough material to presume that a privacy offense under the act has been committed or intended to be committed, release the seized materials, except cattle, on furnishing of a bank guarantee, equal of the bank guarantee to the satisfaction of the court, pending disposal of the criminal proceedings instituted in respect of the alleged offense. Full stop. Para. None of the provisions of section 11, which has provided the power, authority, and jurisdiction to the officers therein, including a police officer not below the rank of sub-inspector, to enter, inspect, search, seizure, and detain. But the no power authority and jurisdiction has been vested on such empowered official, including a police officer not below the rank of sub-inspector, to seal a premise wherefrom the wherefrom any offense like section 13, wherefrom any offense under the act is found to have been committed. Full stop. The empowered official like a police officer not below the rank of sub-inspector can seize any material, including raw meat, suspected to be beef, in an exercise of the powers conferred on him under section 11 of the Act. But he has not been vested with any power to seal the premises. So inspected. Full stop. The a circle officer if he is assumed to be if he is authorized under section, even if he is authorized under section 11 of the Act by the state government, does not possess any power, authority, and jurisdiction to seal a premise, though he may be conferred with the power to enter into a premise and to inspect such premises in order to seize any material from the premises so inspected. Poster. Para, as no power, authority, and jurisdiction has been vested either to the respondent number is found to have been vested either on the respondent number 3 or the respondent number 4 to seal the top premises of the petitioner. Even in the event of committing an offense under the Assam Cattle Preservation Act and the rules framed thereunder, the action on their part in sealing the shop of the petitioner on 10/7/2025 is found to be illegal and arbitrary, found to be an action, found to be an high-handed action, beyond their power, authority, and jurisdiction. In such view of the matter, the act of sealing of the shop premise of the petitioner run under the aegis of Samirul Enterprise, at Algapur Bazaar, is adjust to be legal. Consequently, the respondent number 3 and respondent number 4 are directed to remove the sealing of the shop premises of the petitioner immediately. Post stop. The writ petition is allowed to the extent indicated above.
Investigation will, others, they will take it on board.
Deeply apply.
It is, it is further observed that the sealing, removal of the sealing would not preclude the investigating authority to continue with the investigation of Algapur Police Station, case number so and so, to bring the same to its logical conclusion.
Apply.
Daily list, item number 2.
May please your lordship.
Hmm.
Lordship, I've been led by my senior in this matter. My senior is currently out of station due to public purpose. Hence, lordship may fix another
We
date. for
have
this.
our urgency otherwise, my lord. So on the last occasion, lordship has
Hmm.
indicated in the order that this writ petition will be taken up individually, apart from whatever happening in the writ
What
appeal.
had happened in the writ appeals?
Writ appeal is, next date is fixed on 11th.
11th.
11th. So 3 writ appeals pending
Hmm.
there.
Hmm.
So those will be taken up
Oh,
on
those
that
were
day.
taken up. Those were taken up.
Yes, on the last occasion it was heard and it was deferred on some technical issues. It will be taken up again on 11th.
Hmm.
Lordship, on last occasion, Lordship, I have been asked to provide a corrected copy of the judgment which was passed by the learned Assam Board of Revenue, Lordship, because there
There
is,
in the writ appeal.
because there
Okay,
is,
okay. So, what was transpired regarding this writ petition?
Lordship, can you?
No, what was transpired in the regarding pendency of this writ petition?
It was indicated before the honorable division bench. So since there is an order to that
Yes.
effect that it will be taken up by,
but verbally, Lordship, learned Honorable Chief Justice has said that since subject matter is same, but since the matter has been detached, so we don't want to again take it. So
We'll
if-
put it on any day after 11 then.
Yes, Lordship.
on a fixed
Let us
date.
have,
The Lordship, I fixed it.
But next week will be all motion days last week. After 11.
January first week, Lordship.
No, can it be on 14th or 15th?
14 is Sunday, 15.
Hmm? 15th.
Please nice name for that. Remember?
15 to Oh, it is 26.
Sunday. So immediately after reopening then,
Loss.
because last week is very difficult.
It may take a chance, my lord, subject to laws.
No chance.
We have some urgency because
Oh,
they are
that
enjoying
that
an
hearing has commenced.
Comments, Lord. Lordship, I think,
If,
Lordship,
if that is the thing, if the hearing has commenced, it will have a bearing here. We'll
here
not,
also,
we'll not
Lordship,
go in a, we'll not like to go in a different tangent.
Lordship, here also, Lordship, I will submit a corrected copy of that judgment because in that matter also that difficulty
If
is
the 3 appeals are in staging of the division bench, it is,
that is.
if the hearing has started,
Hearing has practically not started, my lord. So, division bench on the other day, my lord, had taken a preliminary note of the submissions. That is why.
it is 11 fixed, then,
16th,
okay, let it be on 15 then.
15th. Monday.
Lordship.
On 25 Mahajan. 15. A praise made by Mr.
J. Abbas.
J. Ahmed
J. Abbas, Lord.
Abbas Learning Council for the petitioners on the ground that the Padidas, the senior counsel who is leading him in this case is out of station on public ground. Mr. R. Bobazai, Learning Standing Council, Revenue Department for the respondents, state respondents is present. So it is submitted by the land council for the parties that three writ appeals connected with the subject matter in this writ, are ordered to be listed on 11th, 12/2025. To stop. As sought for by the Land Council for the parties, raised the case on 15/12. Interim order.
We would not have traveled, my lord, but only because of the interim protection, only to that extent. And so, items 3 and 4. Lordship may be pleased to peruse, my lord, order dated 15/10/2025. Issue here is, my lord, with regard to, my lord, expansion of the highway, my lord, approaching the Lokopriya Gopinath Bordalo International Airport. The 6-laning project is going on. To that extent, my lord, there are 2 land acquisition cases. And about, my lord, 900 pattadas are involved. Now, that acquisition proceeding has culminated into passing of that award under 1964 Act. And thereafter, notices under Section 7 has been issued to all the pattadas. Out of 900, 7 except this 20 writ petitioners, everybody has accepted the land acquisition compensation. Of course, the land acquisition compensation has been calculated in terms of the parameters laid down in the 2013 Act. So it is higher. Everybody is happy and contented. 7 except these writ petitioners. They
Award
have,
has been passed in respect of petitioners also.
my lord.
Awards have been passed in respect of the petitioners also.
Yes, because award is passed in respect of the quantum of land, the schedule. Now, here in this writ petition, they have challenged, my lord, the initial notices that were issued under Section 3. They were able to get an interim protection from this honorable court. But by order dated 15/10/2025, Lordship will kindly see this order, my lord.
15/10.
15/10.
1810. 1810 perhaps.
18. No, I'm so sorry, my lord, it is 1811. 1811. By order dated 18/11/25.
Let me read.
my lord.
Yes.
Now, I'm thankful to him. My lord, now after this order has been passed, interim is vacated. Now, my lord, we have also submitted the instructions on 18/11. To the extent, my lord, the work is almost complete. Now, by this time, my lord, the petitioners are already evicted from the part and parcel of land, which is a part of the land acquisition process, and the drains have been, my lord, laid down. Construction is complete, my lord. Now, under that circumstances, my lord, query was posed by this honorable court on 18/11 itself, that since the acquisition has already culminated into passing of the award, nothing further remains. They could have challenged, my lord, the entire acquisition proceedings, albeit because their basic case is that, my lord, they are getting less compensation in terms of 2013 Act and other benefits which are available to a person under the 2013 Act. Then, my lord, under that circumstances, they have filed a separate writ petition, the same petitioners, before the Honorable Division Bench, challenging the 1964 Act, the virus of 1964 Act. And pertinently, there are 3 other matters wherein, my lord, the virus of 1964 Act has been put to challenge. And those matters, this matter has been tagged along with those matters. And there are 2 orders passed by the Honorable Division Bench. Lordship, may we please to peruse this order. The first one is, my lord, order dated 24/11, my lord. And, my lord, the second order is dated 28/11
By these petitioners.
by the same petitioners. Now, the Honorable Division Bench has directed, my lord, the state respondents, that is us, my lord, to file a detailed affidavit, because we have to file a comprehensive affidavit. In one of the matters, my lord, that is 6172, already an affidavit has been filed. Nonetheless, my lord, we will be filing a comprehensive affidavit before the Honorable Division Bench defending the 1964 Act. So that will be, my lord, a debate and, my lord, arguments on law point. Now, having said so, my lord, the petitioner's chief, my lord, factual aspects which emerges. Number 1, my lord, the acquisition proceeding is complete. Number 2, they are.
We have to proceed with the presumption of validity of the 1964 Act, unless it is set aside.
Unless it is set aside. Then, my lord, they are out of their land. They are already evicted. My lord, the construction is complete. And Pattadars, they even accept this, my lord, 20 writ petitioners. Almost, my lord, more than 800 persons have received the quantum of land. So under that circumstances, since the lease is now been taken to the Honorable Division Bench, in my respectful submission, this writ petition has become infructuous. Affidavits are, short affidavits have been filed by the state, my lord, state respondents. And on the strength of that interim order, my lord, the connected contempt case is pending. Wherein, my lord, the PWD, the contemptor, that is the, my lord, concerned PWD official, they have also filed an affidavit.
What was the
denying.
interim order?
Interim order was, my lord,
1912, my lord, 24.
19/12/24.
Not to proceed without following due procedure, my lord.
Following due procedure, and there's a relevant statute.
Now, authorities have proceeded, my lord, by following due
That
procedure.
following due procedure means
Yes.
no, it is not stopped,
It is not stopped,
but to follow the procedure under the 1964 Act.
1964 Act,
And some observations have already been made in the order,
absolutely.
subsequent order, 18/11.
My lord, now my submission is that, once the property.
Limit your submission in the context of the obtaining facts.
Yes, ma'am. My lord, once it is for public purpose, we cannot stop it. We have to give. But thing is that, we are treated as if beggars by the respondents, my lord. as if they are landlords, my lord, prior to coming to the honorable court.
No, you know the concept of eminent domain. What is eminent domain?
My lord, it's true, my lord, but
What is eminent domain?
in the main what is taken, my lord? Property is taken by the Fatima.
So if it is a road,
My lord,
whether it is going to airport or going to a railway station or going to a public institution,
my lord.
I think perhaps it falls under the category of public purpose.
I am not challenging on that, my lord. That is true,
Hmm.
your lordship. That is true, my lord.
No, on what ground you are challenging now as on date?
My lord,
So interim order is as per procedure laid down in the act. Some observation, detailed observation has been made.
my lord, on that day, my lord, your lordship has found I was absent, my lord. because
Whatever
of
is,
some-
whatever, an order is an
But-
order,
but-
judicial order.
but thing is
Just
that, my
because
lord,
Mr. Talukdar is not
Thing
absent.
is that, my lord, neither the section 3A served on us, nor 4(2) is served on us. Only 7(1) after contempt being filed and contempt being violated, again violated,
That
only then.
we'll see into that. Okay, we'll see into that.
My lord, kindly see why we are agitating, my lord. Kindly see, take an affidavit, my lord. Your lordship will see.
Question is, suppose 164 Act is declared to be ultra virus,
Yes,
then you will get all the benefits under the 2013 Act,
my lord.
right?
Yeah.
And if it is not set aside,
My lord.
then this challenge, whatever is, it will remain.
Yes, my lord. And what happened, my lord? This petition they have filed correctly, my lord, but we filed before this 18 order, my lord. 1810, 1811 order, my lord. They filed earlier.
Okay, let us proceed then.
My lord,
No point
my lord,
spending time.
and my lord, if your
Let
lordship.
us have the facts first.
Yes, my
Law later on. Who are you?
My lord, kindly notes, my lord, a note I have made. By day. So that your lordship is convenient, my lord.
Petition number 1 is delayed Horibilas. 1 to 5 as one of Roni. As joint owners of land by way of Horibilas and land. Dark numbers. This is dark number, single number. For all.
Next Korea. Kolkata.
So 1 to 5 are from same parcel of land.
Yes, my lord. What my London friend is saying, my lord, that others are not, my lord. What they have done to us, my lord, I don't know for what it is. They have taken
No,
one.
let us facts, not submission. Let us have the facts first.
Yes, my lord.
Not submissions. First, I have to know the facts, then I can appreciate all your submissions. Right?
Yes, my lord.
Whether relevant submissions or irrelevant submissions, then I can only consider. Right?
Yes, my lord.
Let us have the facts first. 6. 3 kotha. Is the owner. Mr. Barbuzari, take a piece of paper.
Well,
7 to 10 are from the same family. 11 to 14 are from the same family. 15 are from the same family. 7 to 15 are also, are joint owner of so and so. 1 bigha. How much these petitioners owned?
My lord,
Total?
one bigger, some land.
Total.
Yes, my lord.
All are from village Gorol.
And Mirzapur, one is from Mirzapur, my lord. Only 6 is from Mirzapur, my lord. But remaining all are from Gorol, my lord.
Yes, okay.
1 bigha, 19
there is
lesser.
no dispute that you are owners of the land.
1 bigha,
Okay.
19 lesser, my lord.
How much?
1 bigha, 19 lesser, my lord.
Does not indicate Total, I have asked you for total. Mr. What was the count?
Yes.
Okay, two LA case.
Yes.
LA 2000. What
Yes.
is the case number?
Yes, my lord, I'm spelling it out, my lord.
LA 12 and 13, my lord.
12 and 13,
Of 2000,
25.
2025. Okay, who are the petitioners under 12? LA 12?
My lord,
You said
LA,
one is from,
on,
this is LA 12 is Gorol or?
my lord,
13
LA 12
Gorol?
is from Mirzapur, my lord.
Huh?
LA 12 is Mirzapur.
Is it LA 12 is
Mirzapur and petitioner number 6, my lord,
Mirzapur.
only.
Yes,
And 13 is Gorol.
13 is Gaurav.
And
This is 24, my lord, I'm sorry.
petitioner number 6. You
my lord,
say
LA
petitioner number 6.
Yes, my lord. For all
For
other,
Mirzapur.
Mirzapur. Others are from
So
Gorol.
petitioner number 125 and petitioner
7 to
number
20.
7 to 20, my lord.
7 to
20.
20,
Are from Gorol village.
20,
Gorol village, my lord.
20,
Up to 20, my lord.
20,
20, up to
20 from Gorol.
Hmm.
Okay.
And
And what are the total areas of land
My lord,
they were owners?
my lord, so far as I have, my lord, calculated, it is 1 bigger 19
By
lakh.
LA case number 12, how much areas were acquired?
Yes.
My lord, LA case number is not 25, my lord, 24, my lord. Yeah, 24, my lord.
24, I'm
24,
sorry.
yeah,
24.
20,
Yes.
12 of 24.
Ah,
and
how much
30 of-
areas were
Yes.
acquired?
Lordship may have this.
Tell me,
My lord,
you have the notification.
yes, yes,
Let
notification.
us have.
These are the section 3 notices, my lord, wherein, my lord, the.
No, ultimately, that is requisition. Oh,
But
that is requisition. What is the acquired?
acquired same.
Because you said 7, you said section 7.
Yes,
So that before that, section 6.
section 6.
So what was the area of land?
Area,
Why you are giving me botheration to look into it?
no, my lord, no. But I,
See that?
yes. But if lordship is taking up those two branches, my lord.
Tell me.
Yes, my lord.
It,
so
it
far-
must be
yes, yes.
bighas, kothas and lessas.
Yes, yes. Total it is 6 bigha, 2 kotha, 14 lesser.
Which one?
LA 12, 12,
6?
12.
12, 6 bigha,
2 kotha, 14 lesser.
2 katha,
14 lesser.
14 lesser.
Yes.
LA 13,
LA 13 is, my lord, 21 bigha, 7.5 lesser.
no kotha,
No kotha.
no kotha. 7,
7.5 lesser.
okay,
21 bigha, 0 kotha, 7.5 lesser.
okay,
That is pertaining to LA 13 of 24.
okay.
And so far as LA 12 of 24 is concerned, my lord.
6 bigha, 2 katha, 14 lesser.
14 lesser, yes.
Okay.
Let
How
us-
much areas the petitioners have?
The petitioners have,
Yes, Talukdar.
My lord,
so that breakup is.
well, so far as, my lord, I have calculated 1 bigger 19 lesser.
You said petition 1 to 5, 1 katha, 1 bigha, 1 katha, you said.
My lord, their total land here is there, my lord.
Petitioner-
And they have,
So total acquired land according to you
yes, my lord.
is
1 bigger, 19 lesser.
no katha.
19, my lord, 19 lesser. No kata, no kata. my lord.
So petitioner's land
So this person get it, they quantum to the.
acquired 1 bigha, 19 lesser. And in LA case number, how much beneficiaries?
But 13 of 24, matlab, there are 800 and, sorry. Total matlab 729 others.
729 beneficiaries.
Yes, matlab.
Okay. And in 12?
In LA case number 12. Total patadars are 183.
183.
Yes.
So except these 20, others have received the amounts.
amount has been,
Subject to protest maybe,
No.
whatever.
PWD has deposited the amount to the deputy commissioner. Already, Malad, they have been communicated to come and collect the amount. That process is going on.
Okay.
Malad,
Now, Mr. Taludar,
petitioner number, just one information, Malad. Petitioner number 6, he belongs to LA case number 12. And other petitioners belong to LA
have
case number
noted.
13. Lordship.
I have noted.
No.
Okay, take me to section 3. Which you have alleged that not served
My
or,
lord, 2, my lord.
huh?
Section 3(2).
Let us have your document first,
Yes, my lord.
so that I can have a fair idea. Okay, annexer A, B, all your land documents.
B1, my lord, yes, land document.
So nobody has disputed that,
Nobody
right?
disputed, my lord.
Nobody disputed? Your ownership is not disputed?
My lord, not disputed, my lord. Only one thing is that, my lord, someone's name is entered who has no connection with this land.
Whatever, you are the successor in interest.
Yes, my lord.
Okay.
Now, my lord, kindly turn to page, my lord, 63, my lord. A series of documents I have annexed, photographs of the my lord, surrounding lands, my lord.
What they have to do?
My lord,
photograph?
my lord, thing is that, my lord, this land was supposed to be reclassified by the government, my lord. It is
Huh?
not done. Reclassified by the government. Supposed to be done by the reclassified.
Suppose is different thing.
My lord, because under land takers manual, they should have done it, my lord. Once there is no cultivation for 10 years, they should do it. But as per land takers manual, rule 23 and 79.
Which one?
Assam land takers manual, rule 23 and 79.
Land records manual.
Yes, ma'am.
That is not enforceable.
My lord.
That is not enforceable in law.
And also,
Assam Land and Revenue Regulation is different
my lord,
and Assam Land Revenue Manual is different.
my lord, records manual, my
Records manual, yes, that is different. Whether it is under Assam Land and Revenue Regulation,
but so subject to your lordship correction, my lord, it is not
subject to your submission,
No, my lord. Subject to your lordship.
whether Land Records Manual are enforceable in law,
my lord,
like directive principles
yes,
in part 4 is not enforceable,
my lord.
right? Or any other which is not law is not enforceable. Now, whether Land Records Manual is law,
Like your lordship, my like preamble, like
let us see Assam Land Record Manual. I don't think it is enforceable in law. It has not got any statutory thing. Rules different. Settlement rules is different. Right? Assam Land Records Manual. Which book? Which book? আৰু সেউজীয়াখন আছে নেকি? Land Records Manual ক'ত আছে?
my lord, as per rule,
This book or that green book?
my lord, I have not the book, my lord, I have collected from photocopy from someone else.
Which book?
That's name is Assam Land Records Manual.
Now, see the top. It is rules or regulation?
My lord, the name is that, my lord, Assam Land Records
Let us
Manual.
have a
Yes.
glimpse. $400, $300, 84 of us. 384. Take me to the statutory provision in the Assam Records Manual.
My lord, which one, my lord?
Normally,
23.
there used to be a preamble
My lord.
in every act or every rule. Take me to the statutory rule which has been referred to.
My lord, 23, my lord, kindly.
No. At the preamble, at the top, at the very beginning.
Beginning, my lord.
Because you are seeking enforcement of it.
My lord,
The very question, basic question is,
my lord,
you are seeking enforcement of Rule 23. Is it not?
my lord.
Now, normally in an act, there used to be a preamble. Similarly, in rules, in exercise of powers under so and so, where is that?
My lord.
Take me to that.
My lord, in my copy, it is not there, my lord.
In my book also, it is
start
not
from
there.
Rule 1, my lord.
In my book also, it is not there.
So, my lord,
Right?
my lord,
Let us go to 23.
23, my lord. My lord, may I read, my lord? Altered assessment of fields converted from agricultural to non-agricultural use. The recorder will also, during his winter tour, make a list in Form K appended of all fields which have been converted from agricultural to non-agricultural use and are liable to altered or additional assessment under the rules framed under the Assam Land Revenue Reassessment Act and submit the same to the sub-deputy collector not later than 15th of February. These lists are to be checked by the sub-deputy collector during his spring tour and submitted by him to the deputy
This
commissioner.
is by the recorder, he has to make a list
Yes,
which have been converted. Right?
my lord.
So, who has the conversion power?
Yes,
There
my
is some act.
My
Let
lord,
us
yes.
have the act.
My lord, coming to my lord,
2003 Reclassification Act.
my lord, kindly turn to my lord, Rule 59, my lord. Record of land use, my lord. The nature of current utilization of uncropped land, both settled and sarkari, and its area will be recorded in column number so and so, so and so. For the first, second, and third year respectively, the class of land used to be recorded here will be one more of the following classes. My lord, forest, barren, and land put to non-agricultural uses. Then, my lord, kindly come to below, my lord, starting the paragraph, all lands under house, my lord. All lands under house site, bosti or bari, with its subclasses, trade site, pepper or thai, with its subclasses. This is used till date, my lord, this pepper or thai and all these things, my lord. Road, railway, burial and cremation, grounds, schools, temples, mosques, playground land, and fishery pond land under embankment, bonds, and reserved for other public purposes will be recorded as land put on non-agricultural uses. So, my lord, the authority is supposed to make it, ought to have make it, my lord. Then, my lord, your lordship may come to 74, my lord, rules. In the anyway, my
Rule
lord,
will be misnomer here. It may be a clause.
maybe, my lord, clause. I may be wrong to say rule also, my lord. Clause, maybe, my lord. In the annual
Yes,
Jamabandi,
it has any statutory backing.
not executive instruction, my lord. It cannot be said there is no signature, nothing, none, nothing, my lord, like this, my lord. There someone is saying so, my lord, not that, my lord. But
No,
NT kindly
no, no,
74,
that
my
is-
lord.
I have asked you.
My lord,
I have asked you the question that suppose, let us forget about this plan acquisition, requisition process. Simply take this manual. Then whether for enforcement of it, whether you can file a writ petition seeking a mandamus.
my lord, I am not only on that, my lord. It is the just one of them, my lord.
That is why I am, since you have raised this question.
Yes,
This has to be considered, right?
my lord.
So if one has to consider, the court has to consider, it has to consider it from all angles.
Yes.
Right? That you just hint a point, thereafter you jump to the other point.
Your lordship is for all, my lord. For all. My lord, my learned friend says guidelines. If it is guidelines, whether it's to be followed or not to be followed, my lord. That is, my lord, kindly see my 74, my lord. My lord, entry of land classing in the Jamabandi. In the annual Jamabandi, column 6 and 7 will be filled up from the relevant column of the Chita in accordance with the nature of land use in this, my lord, I will harpoon, my lord. Our land is not in use for agricultural purpose for more than last 25 years, my lord.
Those are questions of fact.
My lord. Well, now, some documents I have annexed, my lord, in this regard
Yeah,
also.
so there-
Some
there-
documents I have annexed.
For reclassification, all this, you could have applied.
My lord, as per 1615, I have to apply.
Huh?
As per law 15, my lord, we have to apply, my lord. That is true, my lord.
Then at least your application,
My lord.
you have a right to be considered.
My lord, kindly then
But-
last line, my lord. Turn to page, my lord, sorry, 107, my lord. 107, my lord, E, my lord, A, B, C, D, E, my lord. The recorders work in the winter tour will under the following heads. Among other things, my lord, preparation of a list of fields converted from agricultural to non-agricultural uses. And details are given. with the research.
Which rule, according to your permission, which rule?
My lord, 107. The,
Operation of cold weather tour.
My lord, yes, my lord, weather tour and E, my lord. Preparation of their duty is to, my lord, here may mention, my lord, preparation of a list of fields converted
So,
from agriculture
We
to
have
non-agriculture.
come down to recorder.
Yes, my lord, recorder, yes, recorder is there, my lord. Recorders,
We have come down to the duties of recorder.
my lord,
Okay.
my lord,
Okay,
one, my
Let
lord,
us proceed further.
my clause one, my lord.
Yes.
Recorders,
Recorder has been Mondal.
my lord, perhaps like the recorders are appointed by the deputy commissioner, but during the resettlement period, additional temporary recorders purely for the purpose of resettlement operation may be appointed by the
Yes,
settlement.
let us take to the events.
Yes, ma'am. Then, my lord, in case of that, details is there, my lord. My lord, what happened, my lord? In the month of July and August 2024,
Acquisition Act 64 are
My-
rules. Mark Whittle. Yes.
my lord, in the month of July and August 24, some persons, not knowing who are they came to our land repeatedly, sometimes saying that we will take this much land, sometimes saying extending it again, then again extending it again, but giving no clear picture, my lord.
Land Acquisition Act, no like.
Without any notice, without anything, simply, my lord, they said they are sent from the DC office, my lord. Nothing given to us. Minimum notice had it been given to us, my lord, we would have come to know what is happening, my lord. We do not know what is happening to on our land. Quite for 6-7 months, my lord. They are doing X, Y, Z things, my lord. Constructing shed, my lord, digging our land, but they are not saying anything to us, my lord.
And
I have details given in my petition, my lord. My lord, in paragraph 6, my lord, and paragraph 5, my lord, that the petitioner begs to state that few months back, the petitioners came to hear that the existing 2-lane airport PWD road that is filed in November, my lord. Till we do not know what is happening, my lord. They are saying a notice to us on in the long before, my lord. If they can show a single notice served on us, my lord, on month, then my lordship will decide, my lord. My lord, that the petitioners beg to state that few months back, the petitioners came to hear that the existing 2-lane airport PWD road will be upgraded and widened into 4-lane road, starting from Darapur so to 17 to intersection point with the same national highway number 17 at BIP point via Korol Mirzapur, new gate of new terminal of the Lokopiyog Badaloi airport and via existing gate of the LGBI airport with roundabout points at 3 locations. Some days thereafter, the petitioners again came to hear that the aforesaid road will be upgraded and widened from 2-lane to 6-lane, as 4-laning of the road was not agreed by the Adani Group, the present lease of the lessee of the aforesaid LGBI airport. Thereafter, again, the petitioner came to hear that the said existing road will be more widened to 8-lane road, including 1 service road in each side and wide drain cum footpath in both the sides, along with 3 meters wide green median at the center of the road with roundabout junctions in front of the new integrated terminal building and new gate of airport, and another at existing airport gate, another at BIP intersection point, along with elevated arrival and departure roads to make signal-free junction and congestion-free traffic on the new airport road. The width of the road will be 45 meters in all, having 10.5 meters plus 10.5 meters wide 6-lane road, 3 meter wide green median in between with 1 service road at each side, consisting of 5.5 meters each and 3 meters wide drain cum footpath in each side. It is also heard by the petitioners that from the initial sanctioned amount of rupees 358 crores, it is increased to 900 crores of rupees and is sanctioned for the purpose under Prime Minister Development Initiative for Northeast Region, under Ministry of Donier, Government of India. 7, my lord, that few months back, some persons came to the land of the petitioners and started to measure upon the land of the petitioners with tape and making some demarcations by putting small pieces of bamboo encroaching over the petitioners' land. On protesting to do so, petitioners were told by them they are from Ajara Circle Office and from DC Office of Kamrup Metro, and that the existing road will be widened and it is to be ordered by the district commissioner, and that notices will be served to the petitioners landowners very shortly. Thereafter, my lord, another few weeks, another team of similar officials came to on the land again, started measuring and marking the land with the similar pieces of bamboo by removing the earlier bamboo pieces and by extending the earlier area further. On making verbal objection, the petitioners were told again that notices will be served on them shortly and that they will get compensation. On requesting them to supply the photocopies of the documents orders on the basis of which they are doing such works upon the land, they refused and left the place. On the next day, the petitioner went to the office of the Circle Office, Ajara Revenue Circle Office, and to the office of the District Commissioner, Guwahati, inquired about the matter. Then they said that land will be acquired for the aforesaid purpose and it will be further widened as the management of Adani Groups wanted to make it 8-lane road with service roads in both the sides, along with large drain cum footpath by each side. So the petitioners will get the notice after the finalization of the width of the road to be widened and will get their due compensation. Accordingly, the petitioners were waiting to get the notice and the final idea of the area of the land that may be acquired by the respondents for the purpose. But unfortunately, till November, my lord, no such communication notices issued served to the petitioners. The petitioners also tried their level best to know about the matter from the official website of the District Commissioner, Guwahati, but very strangely, no such notification either in public or individual is found in that official website of the District Commissioner, Kamrup Metro, Guwahati. Thereafter, the petitioner again went to the office of the Circle Officer, Ajara.
Let
to
us
the-
have the section 3.
My lord.
That is.
Section 3, my lord, among others purposes, one purpose is transport, my lord. My lord, 3.1, my lord. So my learned friend,
Where is the notice?
yes, 3.2, no notice, my lord. No notice. That is the beginning of the problem. That's why we filed the-
Mr. Nath, please take me to the notice. We don't think the coordinate bench
My lord.
has recorded it wrongly.
We have given the copy, Madam.
Is it part of the record?
No. We served the copy. In our affidavit, we have stated the copies I had, Madam.
My lord, several affidavits filed in my lord, in both the cases, my lord, but nowhere except, my lord, only statement, my lord, no document, nothing, my lord. 7.1, they have annexed, my lord. 7.1, they have annexed, my lord, very strongly made submission also, my lord. But 3.1, 3.2, 4.2, no mention, my lord. No, sorry, my lord, no records, no document, my lord. My lord, we are treated like a beggars and they are the landlords, my lord. The officers are landlords, my lord. The main thing is that beginning, my lord. My lord.
Talukdar, when I am looking at something,
Sorry, my lord.
I am not a multitasker.
My lord, sir.
I hope you have understood. Have they signed?
No, they have not signed. Well, kindly see the second page of the first note, Manoj. The notice I have given, kindly see the second page.
I have seen.
Contempt.
Right, sir.
And where is your gazette notification under section 6?
We have in affidavit said that it was published, but copy I don't have. I can produce it. I'll furnish it. In our affidavit, we have said no.
Which paragraph you have said?
Lordship, we have filed a rejoinder affidavit,
Rejoinder.
affidavit on
By respondent number 7?
seven, my lord.
Hmm.
Kindly come to running page number 245, my lord.
240? But here, it starts from 255. You can say the paragraph,
There are two, my lord, two affidavits.
two affidavits.
Two affidavits. One affidavit starts at page number 242.
242.
Lordship.
242. No, something wrong.
My lord,
Something wrong.
a rejoinder affidavit by the respondent, rejoinder affidavit filed by the respondent to the affidavit in reply. Para 4.
Rejoinder affidavit. One. Two, yes. Which one? First one or second one?
First one.
First one.
Lordship.
Page.
Para 4.
Para-
Para 4 starts at, I have my lord, marked it, it is at as 243, page number 243. Possibly
243.
paginations, some difficulty with the pagination. No? Kindly come to the next page, my lord. Para 4, next page, my lord.
There is no para at all. Okay, para 6 I have seen. Para 5. Okay, para 5.
Para 4, my lord.
Para 4.
Second,
Para 4.
second page, in fact.
Second page.
Second page affidavit, para 4. Then kindly come to the next page. Accordingly, notification has lordship got, my lord. Notification under section 3(1) of the Assam Land Requisition and Acquisition Act 1964 has been issued in respect of village Goral for land measuring 21 bigha 7.5 lecha, vide order number so and so, dated 9/7/2024, which was served to the concerned Patada stroke Gao Pradhan of village Goral. Subsequently, notification under section 6(1) of the LA Act number Act of
Do you have the
1964.
copy of the gazette?
Gazette copy, right now I don't have, my lord. I'll give, if lordship permits me some time, my lord, I'll submit, my lord.
And according to you, when the notice under section 3 was issued?
Section 3, 9/7/2024,
No, there is section 6.
6 on 18/7.
Huh?
They said it is 8,
Section 3 on 9/7.
9/7.
Then you invoke section 6 on 18/7.
18/7.
And when the notice under section 7?
Section 7, my lord, we have annexed. In the first affidavit, my lord, we have annexed. This is 27 to 25, my lord.
27, 2 or 3?
2, my lord.
Huh?
27-2. It was served on 4/3.
Well, 4/3 sub 7/1, my lord.
7/1. Lordship is asked about 7.
When 7-1?
Notice was issued on
7-1,
Sev-
section 7.
7-1, मतलब the page 118 and actual A series.
No, your pagination is not matching.
27 to 25.
27-2,
2.
2025. So according to you, 3-1 section 3 subsection 1 on 9/7, 2024. Section 6 subsection 1 is on 18/7, 2024. Gazette we don't know.
We have said, madam, Gazette is
You have made a statement,
Made a
but very vague.
Uh,
Published in Assam Gazette, no date is mentioned. Then 7-1 on 27 to 2025.
25.
That is your case. These are the dates.
Lordship.
Okay. Now, yes, Mr. Talukdar, what you were reading?
My lord,
What you were reading?
my lord, section 3(2), my lord.
No. You were reading just before.
Petition, my lord.
From the petition you were reading.
Yes, my lord.
When they visited all this, you were reading.
Yes, my lord.
Which month?
That is, my lord.
Few months.
We have filed in the month of November, this petition, my lord. Before
Ah.
that, we are talking.
Few months. This
Few
is
few
of
months from month
2024.
of November,
Few months back.
3 months back,
Ah.
before November, my lord. Because, my lord, at that time they repeatedly came but said nothing, my lord.
When did you file it?
My lord, in the month of November, my lord. Exact date,
November.
November, my lord.
File November. So
Correct.
not clear, few months.
Exactly, my lord. They come repeatedly, my lord. Exactly, my lord. It is not measured and date is not kept recorded, my lord. They're coming and going, my lord, repeatedly, giving no clear idea of how much they will take, when they will take, no notice, nothing. And paragraph 9, my lord, of my petition, my lord.
There is no sign, sir. Mr. Nath. Mr. Nath, there is no signature in this. Who has made this statement? Pisar Putile. To Visarpati,
Yes, sir.
somebody is writing. On which date he is writing?
But it starts as Azi 12/7/2024, madam.
12/7.
12/7.
Some.
Second.
It is the context, but where is the signature?
You get that? No, it's not. But this is the report of the Jarekara.
No, where is the Jarikar?
He has not mentioned his name.
Is it anything? Does it mean anything?
But ultimately he wants to say
If nobody takes the accountability,
the
Gao Pradhan, his
Ga-
signature is not there.
the Gao Pradhan's phone number he has given.
A phone number. Tell me, Mr. Nath, as a senior government advocate, as an officer of the court, not senior government advocate, whether mobile number will bring in the accountability.
Signature would have been better.
If it is done so, then person has to make himself responsible by subscribing his signature somewhere. He can make lofty statements. But whether it is accountable, whether the district commissioner should go by this endorsement.
This is.
We
what-
know that state has the power to requisition and acquisition. In all these matters, only it is the process. See your, I have now doubt whether when the Gazette was published.
Lordship may kindly consider there are 800 and more than 800%, my lord.
Oh,
And
That is a different, yes.
lot of persons, my lord, they have signed, they have accepted. And my lord, in fact,
That does not mean that the petitioners who have raised the grievance, their cases are to be
Right.
discarded. They have made a statement. The state has to be fair.
my lord, kindly see,
If
although
there is, it is there, then please show me date and signature. Yes, Mr. Borbudari. You can also help him.
It's true, Lordship is absolutely correct. Sometimes it so happens, it happens, my lord, that
No, if he's a government officer or official, then he should take the responsibility.
then perhaps, my lord, we will have to produce the entire records of the case, my lord, this proceeding before this honorable court.
Because in some
Because-
cases, the Supreme Court are very,
No,
Supreme
my
Court
lord,
decisions are
one-
very strict. So far, you have the power as an eminent domain to take over requisition, thereafter acquire whatever they have challenged. Normally, if it is the thing is for permanency, no question of requisition. You know very well. So within 10 days, you have acquired. You have exercised the power under Section 6. You initiated Section 3 on 9/7,
nice.
and immediately after 9 days on 87, you exercised. I am not going to say much.
One
The
aspect to be submit as such. Lordship will kindly appreciate one aspect of the matter. That is, my lord, that out of more than 800 persons, 20 are
you
before
will
this
you will be
honorable
harping
court.
on that I know.
My lord, that's it. Now, they have raised their pointed, my lord, my lord, allegation to the extent, my lord, that
Ah.
the notices were
No,
not
Mr.
served on them.
Nath,
Now,
where from you were, where from the court has drawn a privacy opinion that they have refused.
But these are the serial numbers of persons
On-
in the list, my lord, they have refused. The
On
report,
that day, you showed what?
I placed this, my lord.
this one.
This notice I placed. Lordship.
It may not bear the signature, but it bears the handwriting of the Jarikara.
Mr. Morpujari, sometime, on some occasion, maybe,
Because
you'll be on
I
that side
cannot
also.
be on the records. I even cannot submit beyond the records.
Both of you,
I'll be the
both
last
of you
person to do so.
might be on that side also.
But not only the petition,
Let us have,
the report shows that
let us have it one.
there are many persons.
Yeah, basically, my lord, the requisition is entirely founded on the aspect of quantum. If they are happy with the quantum, nothing like that. This is what I understand from a bare perusal of the statements made in the writ petition is premised in such a way, including the prayers. If lordship see the prayer, my lord. I will submit
no,
my
no.
lord.
Signature is not there
Yes,
of the official, but notices signatures are there.
And those
Well,
persons who have refused, my lord, their serial numbers are there.
In fact, that particular remark says that they have refused to sign the notice. They have not received and not signed. And some persons, my lord, they have accepted and signed, put their signature. In a notice itself, those signatures are available.
7-1.
Yes, privacy process was undertaken to serve notices. Though the official responsible for serving the notice, he did not subscribe his signature, but signatures are appearing for many of the notices.
Many persons.
So
And
it
there is no
cannot be discarded also at the same
There is
time.
no reason for not serving, my lord.
Right.
My lord, regarding the numbers, my learned friend is saying 800 something and not doing and what happened, my lord. Kindly, my lord, may I be allowed to read 23 paragraph, my lord, and 24, my lord. Paragraph 23, my lord. Why? Why we are before your lordship among other conditions, my lord? What happened to us, my lord? How we are suffering because of 64A under those respondents, my lord? Kindly have a look,
Yes.
my lord. That the petitioners, paragraph 23, my lord.
Paragraph
Paragraph 23, my lord.
23.
Then the petitioner begs to submit that as the land of the petitioners, their parents and grandparents were acquired earlier for similar public purposes, widening of LGBI airport, enlarging of the runway, and for construction of the existing two-lane airport road. Considering those facts, the respondent concerned ought not to acquire the entire required land from one side only. In our case, they have taken only one side. One side it from the land of the petitioner. Rather, they ought to have taken the land equally from the both the side of the existing two-lane airport. Other they all entire out of 7 kilometers, my lord, they have taken fraction of land, my lord. Somebody cannot come, my lord, cannot spend money on that, my lord, coming to High Court and can run, my lord. They are taken such a small amount, but in our part, it is double taken from one side, my lord. Had they allowed us to make some hearing, to make some objection, we could have placed it before them, my lord. So you take it at least from one side or from the both the side. Now, my lord, and 24, my lord, that the petitioner begs to submit that till the final disposal of this petition, the respondent is required to stop any further works upon the land of the petitioner's Miadi Patta land, as because once the respondents are allowed to continue with their work of dispossession and demolition of their existing business establishment, and or once the project is completed, the petitioners may have to run from pillar to post for their compensation for decade after decade, as they are very painfully suffering till date to get their compensation about due in the acquisition process started in the year 95-96.
What did you do for getting this money with interest in the earlier acquisition process?
My lord, those who have given the land, they have expired. Now,
Since you are prosecuting this petition,
my lord,
as a successor in interest of those
95 case, my lord, 95 year 95 case, my lord. Till we have, my lord.
No, you have the power, you have the right to get the compensation.
My lord, today I have given the,
My lord, prosecuting this means
my lord, today I have given the land to the government.
that
My
cannot
lord,
be a ground.
My son or my son-in-law will get the money, my lord. But sorry, my lord, grandson will get the money. My lord. My lord, this is happening, my lord, under the hand in the hands of the government.
So what did you, how did you pursue for not getting the compensation in respect of earlier?
Yes, my lord. Your lordship is correct.
You have not
There are
seen.
many factors, maybe there, my lord. Correct, my lord. But lastly, my lord, I
No,
have
let us,
annexed.
what is your ground?
And
I have seen
I
paragraph
have, no,
23,
I have annexed the
24.
document also, my lord, how they have gone to
I have
Supreme
seen
Court.
paragraph 23 and 24.
No,
Now,
in addition to that, my lord, I have annexed those documents, my lord. Those 95 LA case, my lord. How they have went to the Supreme Court, my lord, by deferring. Supreme Court dismissed, my lord. And till they are deferring by
I accept it to be true. I accept paragraph 23 and 24 to be
my lord,
true.
my lord.
No doubt. True. We'll say. Yes, what is?
My lord, thing is that, my lord, section 3 violated, 3-1 violated, 3-2 violated, my lord, 3-4 violated, 3-3 violated, my lord.
Tell me, what are the violation?
My lord, they have not served any notice, given us no time, even 54 activities, my lord.
3-1 violated.
My lord,
Then?
the order under subsection 1 minor shall be served in the prescribed manner on owner of the land, and where the order relates to land in occupation of tenant also, my lord. Then when the order of requisition is made by the authority other than the state government, any person.
Put the section.
Yes, my lord,
3-1, then?
Section 3-3, my lord.
3-3.
My lord. 3-2 and 3-3, my lord.
3-3.
My lord.
And?
3-2 and 3-3, my lord. Both. And my lord, they violated both of them, my lord. Then, my lord, kindly turn to, my lord, section 4, my lord.
Section 4.
My lord, yes.
Section 4, which part?
My lord, 3, my lord. Subsection 3, my lord.
Subsection 3.
An order under subsection 1 shall be served, my lord, in the prescribed manner on the owner of the land. Not done, my lord. My lord, 6-1, perhaps
6-1.
yet not been done. I am not sure. They are saying, but no document is annexed, my lord. 6-1 is perhaps not done. 6-2 is not done, my lord. But I am not sure. I have not on that, my lord, because I am not interested to gazetted or not gazetted. What is the use of me to me, my lord? But my lord, 3-2, 3-3, 4-2 is clearly violated, my lord. Notice 7-1 served on us, my lord, after contempt being filed, my lord. 7-1 served on us, my lord. Only that is, we are admitting, and they are showing the documents also, my lord. But it is quite, my lord, I have, my lord, clearly and categorically made statement in my affidavit in reply, my lord, paragraph 6 and paragraph 7. It is how they have violated. And my lord, continuously, even after contempt being filed, contempt notice being served, my lord, they were forcibly trying to dispose us. Again, and again, with photographs, I have annexed in the contempt petition, my lord.
No.
So badly we are
section-
treated,
no,
my lord.
Mr. Talukdar,
My lord.
if I remember correctly, section 6,
My lord.
section 6 permits subsection 2. That is why I asked for the official gazette. Permits them
Otherwise, copy I have, official gazette is not.
saying that the land vested absolutely in the state government, free from all encumbrances, and the period of requisition of such land shall end. Right? A requisition is that they take possession.
Yes.
Ownership remains with you.
After following 3 and 4, my lord.
Ownership will remain with you. But acquisition, possession goes, ownership goes. Right? So as soon as the gazette is, order is published in gazette, then from that day, the land gets absolutely vested. According to them, it is 18/7/2020.
But till date,
Prior to filing of the writ petition.
prior to, my lord.
Prior to.
As per them, my lord.
No, if it is gazette, then by law,
My lord,
then by operation of law. Right? 6:1 published in the gazette,
my lord.
then by virtue of 6:2, possession goes and ownership goes as soon as the thing is published in a gazette.
Gazette, my lord.
Right? Thereafter, they can enter and do whatever.
My lord.
Next will come the
7-1.
subsection 3, Land Acquisition Act
My
repeal.
lord.
So all provisions will be applied. Now section 7
Hello.
will come, please come and take the compensation.
Compensation.
Right?
Yes.
And you can receive it under protest. And thereafter, I think there is referral provision. 11. Referral provision, it may be quantum. And so far, if your reclassification, have you applied?
My lord, some of them have applied and some of them after the, my lord, they have applied.
That issue can be raised in that forum perhaps. We are not going into it, whether it's, or because land record manuals, as I have said,
My lord.
that duty of the recorder, Mondal, to say so.
And my lord, then
That
place
duty, it is his duty to do so.
and then to place is before the higher.
Consequence is not laid down.
My lord, it is also mentioned in some other rules.
No, it
then
is
to
not
place it before the higher
enforceable,
authority.
sir. As I have said,
My lord.
unlike land and revenue regulation and settlement rules, these are not statutory rules.
My lord, they cannot go to 6. my
Let
lord.
us have their affidavits.
Before 3 and 4, they cannot go to 6, my lord. Before following 3 and 4, they cannot go for 6, my lord. That is the,
That you have contended,
my lord.
they have replied.
My lord, there is no record, my lord. Your lordship has seen, my lord. No record that they have served notice on us. No record, nothing. 3 and 4, nothing. Had it been there, had it been there,
To
my lord,
proceed further, don't re-argue the same point. I have noted your submission.
Yes.
Right. You said that they have not placed, they have not served a notice upon you. So you are not in a position to annex it.
But had it been served, perhaps
Sure.
different scenario would have been different, my lord.
Yes.
In spite of running to them again and again, my lord, they have not given.
Now let us see the 7-1 notice. When did you prefer the writ petition?
in the month of November, my lord.
Oh, at that time it was not served.
Not served. But even after the contempt file in January, till not served, my lord. Till today not served, my lord. Till date not served. 3-1, 3-2, 3-2.
So, government process takes time.
My lord.
That is why I asked for gazette notification.
My lord, they started work in the month of June, July, my lord. And they are not serving notice till today, my lord. Till date.
July, if it is gazette is published, then they are authorized to do so.
My lord, cannot publish without 3 and 4, my lord. The following 3 and 4, section 3 and 4, my lord.
You have been saying that.
Yes.
This is the 7th time perhaps
But
you are making that submission.
no, my lord,
I have
6 and-
noted it, sir.
6 and 7, I am saying, my lord.
I have noted it, sir. And what about this annexer? Who has filed this annexer? Additional affidavit in reply. What documents you have brought in here? Additional affidavit in reply.
My lord.
You said 3233, 4143, all these are violated. Okay.
My lord, there I have shown, my lord.
Hmm.
My lord, kindly see the page, my lord, 169, my lord. Running page 169, my lord.
169. Yes, which paragraph?
This is a letter annexed, my lord, in my lord, content petition, my lord. Where from I have got it, my lord.
Annexer
Annexer, my lord, 1, my lord. Page 169, my lord.
11/9/2024.
My lord, yes, my lord.
District Commissioner.
Yes, my lord.
Hmm.
They are, my lord, regarding the acquisition of land of the purpose of convert of the existing 2-lane road connection LGBI to 6-lane PM Divine project, my lord. With reference to subject cited above, I would like to inform you that total land measuring so-and-so biga has already been acquired under section 6(1) of the Assam Land Acquisition Act 64 on the basis of LA proposal 6 villages so-and-so submitted from your end pertaining to convert the existing 2-lane road connecting LGBI Airport, Guwahati from VIP Junction to 6-lane road. In this regard, it is mentioned that from Form C under Rule 5 of the Section 4(1) of the Assam Land Acquisition Act was issued to the concerned Patadars, issued but not served, my lord. Only issued, my lord, in their own office, my lord. And perhaps remain in their own table, perhaps, my lord. Patadars on 9/7/24, being the owner, tenant, interested persons in occupation of the said land, it was directed to surrender or deliver possession of the requisition land. And that is 11/9, my lord. And we are filing the case in November till we have not served any notice, no nothing in this regard, except some people are going and coming, staffs are going and demarcating, extending, and doing all these things. Then, my lord, kindly see, my lord. Next, my lord, annexers, my lord. I have annexed for the purpose of showing to your lordship, my lord, surrounding land became the class of surrounding land is Bepar or Thai, all commercial land made, my lord, including the buildings. I have annexed the photographs of buildings, star hotels, my lord, and many business establishments, my lord. I have annexed surrounding, but our land is kept as agricultural land, my lord, and that is why they are giving 1/20th of the real value of the, my lord. They are offering us 1/20th of the real value, market value.
This can be done in 2 ways. I'm not here to advise you.
My lord.
Taking up the plea of reclassification, not done. Secondly, that if your adjacent land is valued at so-and-so and has been given compensation at so-and-so, so your value should also be given. But that is for a referral court to decide after you take up a plea like that, right?
So, my
We
lord,
are not into, sir, we are not into the compensation amount.
no,
This is,
no,
please,
no, my lord.
this is to be
Yes,
raised
yes.
before the referral
Yes.
court.
That's true, my lord. That's true. My lord, I have annexed all the series of documents showing the surrounding lands are commercial land already converted by the respondent, my lord.
Yes, sir. Yes.
Then, my lord, kindly come to page 229, my lord, 2234, my lord.
What kind of document?
My lord, this is the application of some of the petitioners for reclassification, my lord. Filed in 14/12/23, my lord.
Gunojit Das, who is he?
My lord, petition number, my lord, 1 to 5 is there, my lord. All jointly filed, my lord, this.
If it was not delivered, why did not you prefer any appeal?
My lord, kindly then turn to next page, my lord, 234, my lord.
Your
This,
pages
this
are
is given by the, my lord, issued by the Lokchandra Das Mirzapur Revenue Village, Gabula, my lord, that this land is not in use for agricultural purpose for last 20 years, my lord. Given in 23, my lord. Then, my lord, some lands are converted, my lord, some examples I have given, my lord. Then, my lord, kindly come to page 237, my lord, what I have mentioned. The 95 LA case, my lord, this, and kindly have a look, my lord. Our forefathers and some of our parents has given the land in 95, still not been
Which
taken.
annexer?
My lord, page 237, annexer 5, my lord, annexer AR 5 series, my lord. Page 237, my lord.
Huh.
Till the opinion is being, my lord, sought for. Even the Supreme Court has next page, my lord. Supreme Court dismissed all the cases, my lord, filed by
Right.
the government, my lord.
So have you initiated execution proceeding?
My lord.
Have you initiated execution proceeding?
No, my lord. We are only for compensation, my lord. Here, my lord.
To realize that they are.
Yes, exactly. That is only for realization, my lord.
Have you initiated execution proceeding?
No, my lord. My lord. I'm not details, my lord. Not documents with me, my lord. So I'm not
Yes.
making.
Any
submission
other
of that.
pleading from your side?
Yes, my lord. Only, my lord.
Any other pleading? Apart from this,
The gender affidavit.
any other affidavit?
No, my lord. That's my affidavit, my lord.
Okay.
So.
Oh, another additional affidavit, what, for what?
No, that is, my lord, for to bring on record the other matters are going on.
Oh, virus.
Not, my lord.
Virus.
Not required here.
Yes, Mr. Nath. Right from 3-1 to 7-1, all have been violated. That is his case.
That is his key.
And plus reclassification,
Lordship.
not done,
My lord.
right?
My lord,
And partial, biasness, acquiring one side of the road. That is, right?
My lord, exactly.
One side of the
Statement is there, my lord, on affidavit.
one side of the road.
Lordship.
And so 3-1 is no service of notice. That is one.
He says. According
Then
to
one side of the road acquired. Right. Where the petitioner's parcels of land were there. Next is valuation. Less. Then no reclassification
Lordship.
as per the provisions of Assam Land Records Manual. Right? Assam Land Records Manual. Then 4-1. Then 6-1, 7-1.
My lord.
Anything?
Oh, my lord.
Lordship. But, Lordship may permit me to take the.
It may not end, but you get the notification, gazette notification.
Yes, my lord, that
Tomorrow.
I'll.
Okay.
My lord. Lordship may.
Please keep in mind.
Yes. Kindly permit me to take your lordship to the
Please take your
prayer, my lord, made in the writ petition. Lordship may kindly
Prayer.
come to, yes, my lord.
1 minute.
Kindly come to page number 24. my lord.
Okay, 1 minute. 3 knots. Borbudar, you are making separate submission.
Yes, sir.
Okay. Prayer. Thought. Prayer.
Lordship. Just to, my lord, submit before your lordship, what is actually his case, my lord? Just to see, my lord, kindly see his prayer number 1. He prays that the directing the respondents concerned to issue a mandatory notice upon the petitioners, landowners under the provisions of Article 300A of the Constitution of India, the Land Requisition and Acquisition Act 1964, as amended up to 2023, the Land Requisition and Acquisition Act Rule 1964 under right to fair compensation and
Is
transparency.
there any amendment?
So therefore, that is my lord.
Yes, sir. Which has been amended? Assam Land Requisition and Acquisition Act. 1964 amendment exposed. Okay.
Lordship. Then they said that the land acquisition and acquisition rules 1964 under right to fair compensation and transparency in land acquisition, rehabilitation and
2013
Act 2013.
rules.
Assam right to fair compensation and so and so, as well as direction to the Honorable Supreme Court. That is their prayer number 1. Then prayer number 2, reclassify the land of the petitioners from agricultural land to non-agricultural commercial land as per the ground realities and under the provisions of the Assam Agricultural Land Regulation of reclassification and transfer of non-agricultural purpose. Then Malad, they have prayed
Okay, to rule 23, 59, 74.
Lodging.
Uh-huh.
Then Malad, they have prayed para number 3 to direct the respondent concerned to complete the process of requisition and acquisition of the land of the petitioners if so required for the public purpose before dispossessing the petitioners and before removing their shops, houses standing upon their land. Then to direct the respondent concerned to acquire equal proportion of land from both the sides. But in respect of their prayers, my humble submission is, my lord, I'll take your lordship to the individual contention raised by him. In respect of the prayers, my respectful submission is that he has prayed for, ultimately his grievance is as regard the compensation. The quantum of compensation is the main trust of this petition, my lord. He said that he has been given less amount. And if it is taken under 2013 Act, he will get higher.
No, at the time the petition was made, there was no question of acquisition. Perhaps.
In
Is
the
it
one,
not? The date 7-1, acquisition was made,
yes,
but section 7-1 was only 27 to 2025.
lodging. Notice was
So
issued
at
on-
that point of time, that was not the fundamental issue.
in the
Subsequently, maybe.
in the writ petition, the projection made by them is that under 64 Act, some process has been done without following the law, and they have been given lesser compensation. So we are required to reclassify the land as commercial from agriculture and
It is not
and
that they say
there are
that,
two, my lord.
that
prayer-
they let, if you take their land, then that must be done as per the provisions of these acts. And plus, after reclassifying their land into commercial land,
commercial land.
right?
So at best, my lord, they have the knowledge that the land is being acquired. Process is going on. So their land is to be reclassified as per provisions of that as commercial land on the ground realities, and we are required to calculate their compensation accordingly. That is what they have prayed. As regard the equal proportion from both sides, my lord, this is a project, my lord, for expansion of 2 land into 6 land. So there are, my lord, technicalities and my lord, feasibility issues are there. So as per requisition of the authority, requiring authority, it was done. And in fact, lordship, one document, my learned friend, while making his submission, he has referred to that. But lordship may, if takes up that document AR1 in their additional affidavit, they have mentioned, my lord, page number 169. This document has little.
Tell me the annexer, because your page and my page are not matching.
My lord, annexure, their additional affidavit, my lord, it was filed on 28/10/25.
Which document? 11/9/2024.
11/9/24.
I read.
Some relevance is there, my lord, because this document shows, my lord, ultimately we are concerned with 2 LA cases, but in, my lord, actually there are other, my lord, the land total requirement is 51 bigha. But we are concerned with LA 13, where land is required, acquired is 21 bigha, and LA 12, there 6 bigha was acquired. The other land, here, my lord, it is mentioned, serial number 1, 2, 3, 4, 5, and 6. We are concerned with, in this case, serial number 3 and 4. My lord, this letter shows, my lord, the deputy commissioner has informed the executive engineer PWD that I would like to inform you that total land measuring 51 bigha 3 kata 6.75 lecha has been already acquired under section 6(1) of the Assam Land Requisition and so Act 1964 on the basis of LA proposals of 6 villages of Kahikusi so submitted from your end pertaining to convert the existing 2-lane road commencing from LGBI Airport Guwahati from VIP Junction to 6-lane road under PM Divine Program so. In this regard, it is to be mentioned that Form C under Rules 5 of Section 4(1) of the Assam Land Requisition and Acquisition Act 1964 was issued to the concerned pattadars on 9/7/2024. Being the owner, tenant, interested persons in occupation of the said land, it was directed to surrender the delivery of possession and so. So my referring to this letter, my respectful submission is, my lord, it is as per the requirement given by the requiring authority. They know, my lord, they know better. They are the expert authorities. Then how to the alignment of the alignment of the road, how to extend it, and how to convert the road, my lord. So this is in the domain of the expert, my lord. Whether the land will be taken in this side or that side, my lord. My lord, that is an expert opinion is required, my lord. So the deputy commissioner has gone as per the requirement of the acquiring authority. So the prayer made by the petitioner that the respondent concerned should acquire equal proportion of land from both the sides of the middle point of the existing 2-lane airport. That, my lord, my respectful submission is not to be considered, my lord, because it is on the domain of the expert, my lord. Then as regard the demarcation, my lord, on demarcation and the conversion of the land, my lord, at that point of time, it is nobody's case. In fact, they have also not said that our land is a commercial land. At the time of acquisition of the land, as per the revenue records, the lands were whatever the category was there, the authority have gone by that category, and accordingly the assessment has been made. So in this writ petition, they have prayed for reclassification. That means they have admitted that their land is not till date, my lord, it is not categorized as commercial. So they cannot claim commercial compensation by filing this writ petition. Now, kindly take up our affidavit in opposition, my lord. We have filed 1 affidavit in opposition and 2 additional affidavits, my lord. Affidavit.
Oh, 8 no?
First affidavit.
1 minute.
Sheet number 2. No. This one. Yes.
So by virtue of this amendment, 2013 Act is not made applicable. So provisions are not made applicable by this amendment.
This.
New section has been incorporated, 100.05A. And fifth schedule has been incorporated. After the fourth schedule, fifth schedule. The only act is Assam Land and Revenue Regulation.
It came into
And
effect-
the provisions of this act shall not apply.
My lord,
1 minute.
this came into effect in May 25, my lord.
Yes.
My lord, your lordship noted, my lord, this came into effect in the month of May.
I've seen.
Obliged.
Well, in the first affidavit in filed by the respondent number 7, in it's a short affidavit, my lord, we have annexed the section 7 notices issued to the petitioners, my lord,
Okay, 27-2.
27-2.
Hmm.
Their lordship, we have stated in paragraph 4 that paragraph 4 of the affidavit that the executive engineer PWD Roads Jalukbari Territorial Division has deposited the estimated amount of rupees so and so for land and Jirat compensation pertaining to acquisition of land for construction of existing 2-lane road connecting LGBI from VIP Junction to 6-lane under PM Divine program and as SOPD at Village Goral. Subsequently, award of LA case number 13 of 24 has already been approved by the district commissioner, Kamrup Metro District, and accordingly notice under so and so were served upon the concerned parties, including the petitioners, to receive the compensation subject to submission of indemnity bond and relevant documents in support of their claim to receive the land Jirat compensation. But till date, the petitioners have not submitted the documents for which payment could not be made. If lordship kindly takes up the notices, my lord, and annexure 1A series, my lord. One thing, my lord, I just would like to point out. Internal page, my lord, we have marked as annexure page number 124. This is the report of the Jari Karak, my lord. Jari Karak's report, the vernacular one. These are admitted, my lord. Again, he has given the report but not signed. This is how, my lord, I find that he used to give the report. Translated copy we have given, and the next page to the translated copy, my lord.
Where is the report?
Annexure A series, my lord. The affidavit in opposition filed by the respondent number 7. Annexure A series, my lord.
Hmm.
First annexure, it was received by for the second page, kindly see, notice dated 27/2/25, second next page, received by for all 5, one Nilima Das is.
Nilima Das.
Yeah.
7-1 admitted, my lord. 7-1
Yes,
I
yes.
am admitted.
That's, I'm referring, my lord. That is my lord, I'm just referring. Kindly come to the third notice, my lord. It was given to Sunu Ali. Then kindly see the service report, my lord. Third page, my lord.
Yes.
Notice addressed to Biajan Sheikh, Sunu Ali. Kindly see the service report, my lord. Page number, internal page we have mentioned as 124, my lord.
Hmm. Yes.
Same thing, my lord, it is addressed to Bisarpati, then so and so, and no signature is there, my lord. And similarly, my lord, the last page of the affidavit also, these are admitted, my lord. So in this manner only they used to serve, my lord. And this is they used to give the report without without mentioning their signature.
My lord, the signature is there, my lord. Signature is there, my lord.
No, I'm talking about signature of the Jarikarak.
7-1 signature, the receivers are there. Receivers signature is there.
Yeah, I'm pointing out something else.
Yes.
So, Malad, the Jarikaraks used to give report in that manner. Kindly, Malad, thereafter, we filed rejoinder affidavit, Malad. Rejoinder affidavit of the respondent number 7. There we have in detail stated, Malad, the about the entire process undertaken, Malad. I'll correct the paginations, Malad. Kindly have the affidavit, paragraph number 4, Malad.
Yes.
Lordship, the para 4 we have said that with regard to the statements made in para 2 of the affidavit in reply, the deponent begs to state that as requested by the requiring department, that is the executive engineer PWD Jalukbari, land acquisition proceeding has been initiated in respect of village Goral and Mirzapur, Dharapur, Kahikosi and Jogipara under Ajara Revenue Circle on the basis of land acquisition proposal submitted by the Circle Officer Ajara Revenue Circle after conducting joint survey with the requiring department by letter number so-and-so dated 28/5/2024 to convert the existing 2-lane road connecting LGBI International Airport Guwahati from VIP Junction to Dharapur 6-lane under PM Divine Program. A copy of the letter we have annexed at Annexure A. Accordingly, notification under Section 3(1) of the Assam Land Requisition and Acquisition Act 1964 has been issued in respect of village Goral for land measuring 21 bigha 7.5 lecha by order number so-and-so dated 9/7/2024, which are served to the pattadars, concerned pattadars through the Gao Pradhan of village Goral. Subsequently, notification under Section 6(1) of LA Act 1964 has been issued by LA case number so-and-so dated 18/7/2024. The same has been sent to Director Printing and Stationeries, Assam Government Press, Bamani Madam for Gazette publication by letter number so-and-so dated 18/7/2024. Accordingly, land acquisition estimate amounting to rupees so-and-so has been prepared and forwarded to the requiring department, that is the Executive Engineer PWD, by letter numbers so-and-so dated 16/8/2024, which was subsequently received from the requiring department for the total required land measuring 21 bigha 7.5 lecha by LA case number 13/2024. But the DAG numbers of the village Goral are mentioned in the writ petition, also incorporated in the total area. Again, it is to be stated that land measuring 6 bigha 2 katha 14 lecha of village Mirzapur under Ramsaroni Moja has already been requisitioned under Section 3(1) of the Assam Land Requisition and Acquisition Act 1964 by order number so-and-so dated 9/7/2024, which was served on the concerned pattadars through the Gao Pradhan of village Mirzapur. Subsequently, notification under notification under Section 6(1) of the Land Acquisition Act 1964 has been issued by order number so-and-so dated 18/7/2024. The same has been published in the Assam Gazette. Accordingly, land acquisition estimate amounting to rupees 12 crore 31 lakhs so-and-so has been forwarded to the requiring department, that is the Executive Engineer PWD, by letter number so-and-so dated 16/8/2024, which has been received from the requiring department, and payment is going on whose right title are clear subject to submission of indemnity bond and other required documents. Land measuring 1 katha 5 lecha covered by DAG number 175 of Patta number 59 of village Mirzapur under Ramsaroni Morja is also the part of the total required land measuring 6 bigha 2 katha 14 lecha in LA case number 12 of 2024 as referred to above. Well, this is in respect of petitioner number 6. The total amount of rupees so-and-so, the amount of rupees so-and-so as mentioned in the affidavit submitted by serial number so-and-so is against the LA case number so-and-so, and we have indicated that the amounts are in respect of LA case number 13 and LA case number 12. Then, my lord, we have said in paragraph 5 that the acquisition of land to convert the existing 2-lane road connecting LGBI Airport from VIP Junction to 6-lane under PM Divine Program of and SOPDG had been executed as per provisions of the Assam Act of 1964. As laid down in the act, requisition has been carried out under provisions of section 3(1) by the state government. Accordingly, notice under so and so were issued. So, my lord,
This, so far, main ground is 3(1).
3(1).
So you have read. What about this reclassification? He has referred to all these rules. Assam Land Revenue Manual. Classification.
my lord, as per as regard the reclassification, my lord, we have said in para 11 of this.
No, you have
this-
said,
this-
Deputy Commissioner has said.
Lordship.
Now, what is your submission? Deputy Commissioner has said in the affidavit.
My lord.
Now, what is your submission in the context of this and Assam Land Revenue Manual? He said Rule 23, 59 and 74.
But that is a separate procedure, my lord. I'll go by the affidavit. But that is the separate procedure they have to undertake. And they all along, my lord.
No, you don't have to always go by the affidavit.
My lord,
You are you are a learned
Lord,
counsel,
my lord, my lord.
not unlike District Commissioner.
My lord.
So that is why I have asked for your opinion. You will always go by the affidavit.
My lord, they have to pursue.
If he says sun sets in the east, you'll go by the affidavit. No. That is why I have asked.
My lord, even though.
The context of Rule 23, 59, 74 of the Assam Land and Revenue Regulation. He is making it in the prayer. That is why I have asked you.
Lordship. So
So what is the value or sanctity or enforceability of Rule 23, 59, 74?
reclassification process has to be undertaken by the petitioner. Some of them, they have said that some of them have, my lord, applied for reclassification, but they have not undertaken the process, my lord. It is for them to go ahead, my lord. Reclassification. Mhm.
Yes.
My lord, as regard the reclassification, their prayer for reclassification, my lord. My lord, the process, or if they have, my lord, initiated the process, ultimately the prescription of law says, my lord, they have to pursue it, and if it is not completed or it is not considered, they have their remedy elsewhere, my lord. Not in a process, my lord, when the land has been acquired, they will come up for reclassification, my lord.
Yes.
Their prayer for consideration under the Assam Land Record Manual, Assam Land Records Manual, that Lordship has already had Malad. As regard the 2015 Act, Malad, a particular, a prescribed procedure is the, envisages there, Malad. And they have to go through the process, Malad, until and unless it goes. They cannot claim the benefit, Malad. The reclassification is not an automatic process, Malad. They have to undergo with that. Admittedly, Malad, that has not been done as on today, Malad. It is not automatic, Malad. They want to now contend that all the lands of the surrounding area, those are commercial land. So their land has to be considered as commercial. But that automatic conversion reclassification is not at this stage, not under the law.
And their claim for higher compensation will be by the referral court.
It will be by the high, it will be definitely, Malad. In fact, in our affidavit, we have said, Malad. In our affidavit, we have mentioned, Malad. Kindly.
Mr. Borbudari,
Para 6, Malad.
under section 6(3) of the Land Requisition and Acquisition Act 1964, it says about 1894 Act.
Yes.
Now, has it been amended? You have kept it like that purposefully. No. So that so many legal questions may arise. Since 1964 Act is in existence, you ought to have amended as a standing council of Revenue Department. You have the duty to point out if there is omission. Why you wait for arising of complications? So you love litigation or what? No, it is apparent, expressly apparent. It should be amended.
But
Okay.
in para 6 of our affidavit, you have said,
Some, what? Yes.
in para 6 of our affidavit, Malad, we have said that the land has been acquired under section, as per provisions of section 6(1) of the Assam Land Requisition and Acquisition Act 1964. However, the compensation has been determined under sections 26 to 30 of the Right to Fair Compensation Act 2013. And as per provisions of the act, Malad, they have the remedy if they are agree with the compensation amount. That their remedy they have, Malad.
So award has been assessed as per section 30.
Yes, Malad. 2013, and there is a notification by the Revenue Department
Where is
that
that?
in any case, Malad, even if the land is acquired under 1964 Act, the amount has to be, compensation amount has to be assessed as per 2013 Act. In 2015, it was issued.
We have the notification.
Oh, copy we have.
Okay.
Section 12 of 1964 Act, it provides for reference to court. Malad. And in fact, section 12(2) it provides, my lord, so subject to the provisions of this act, the provisions of Land Acquisition Act 1984 shall moteless motendis apply in respect of any reference made to the court under subsection 1. My lord, in view of repeal of the Land Acquisition Act 1984, then, my lord, it will be replaced by 2013 Act. In fact, 13 Act has been followed for assessing the competition.
Yes, Mr. Orbuzari. Anything to add?
So therefore, my lord, in my humble submission, my lord, the grievance agitated by the petitioner that there is no process, there is no land acquisition process. They say, they want to say that there is no land acquisition process at all. Without any process, their land has been, we have interfered with their land. That is absolutely not correct, my lord. There is a process. But not only the petitioners, 20 petitioners, in fact, although there are 20 petitioners, paragraph 2, it makes it clear, my lord, they belong to one family, my lord. Four or five family in one of the affidavit they have said. So out of around 900 persons, my lord, lot of persons, they have been served the notice, and lot of persons, my lord, they refuse to cite, they did not accept. In any case, there is a process. A process was undertaken, section 3 was there. Then, my lord, section 6, it was also there. Section 6 notice, my lord, in the contempt petition, the connected contempt petition affidavit was filed. Section 6 notice was already served on, it is annexed in the affidavit filed in the contempt petition, my lord. It is with them. But, my lord, they have started everything, their case in the additional in the affidavit in reply from section 7. They said that they don't deny that we have received section 7.
Okay, get the notification.
Lordship,
Is it?
my lord.
Yes. Anything to add?
Therefore, my lord, the
Put it the day after tomorrow. We'll
Yes, yes.
dispose of. Yes, Mr. Borbuzari, anything to add?
My lord, may I, your lordship, attention to one.
Let him add.
Yes.
Keep it short. 5 minutes.
I'm thankful to him, my lord. On facts, my lord, he is more acquainted. I will not trouble my lord with facts. Now, the prayer lordship has seen 2015 Act is a self-contained code. It has a overriding effect so far as reclassification is concerned.
Hmm.
And 2015 Act doesn't, my lord, is not extended to the municipal areas and the municipal corporation and notified urban areas under the municipal
Is
act.
it?
That is provided, my lord, in section 1.
2015 Act is not extended
Yes, my lord, if I may read it, my lord, section 1,
to
subsection,
municipal areas.
yes,
Say the section.
section 1, subsection 2,
Section 1.
subsection 2, short title extent. This act may be called the Assam Agricultural Land within bracket Regulation of Reclassification and Transfer for Non-Agricultural Purpose Act 2015. Number 2 is, my lord, important. It extends to the whole of the state of Assam except the districts under autonomous councils formed under 6th schedule of the Constitution of India and except the municipal corporation under the relevant act and the notified urban areas under the Assam Municipal Act
So
1956.
do you say it is urban areas?
Urban area, admittedly urban area,
Urban area.
urban area. Then, my lord, the applications, if at all, any person intend to make any application for reclassification of their land, that application has to be made before the district commissioner. And if the authority doesn't exercise its power or sits over the matter, then there is a provision for filing appeal. Now, these things have not been done. Now, coming back, my lord, to the 1964 Act,
in municipal area, there can be existence of agricultural land.
There can be existence of
No,
agriculture.
I don't know. That is why.
But admittedly, this area,
They apparently these are agricultural land.
this
Classified in the revenue records, whether in municipal areas there can be agricultural land. A question has come to my mind. I am asking you.
Lordship is absolutely correct because in the Jamabandi, the land which has been acquired now still, my lord, retains the character of, my lord, Basti land, agricultural land and Basti land. It is not, my lord,
No,
industrial.
maybe my question is very innocuous.
Lordship is correct.
That
Lordship is
it
correct.
has been declared as municipal areas. Right?
Yes,
Under municipal act.
yes.
Then whether inside the municipal areas there can be
There
existence
can be, there can
Agri-
be, there can be, there may be.
agricultural land.
Yes, there may be. There may be, and
You
there,
are not sure.
I'm not sure to that extent. my lord.
So maybe
Now-
you will not do
Yes.
for me.
Yes.
Because the question has come,
No,
may
no.
not be.
I will make an attempt, my lord, to search it, look
Okay,
it up for it.
next.
Now, they had initiated an exercise before this acquisition was done by the authorities, saying that, look, this is a plot of.
Few of them.
Yes, few of them. Now, this land is to be reclassified as industrial land. From agricultural land to industrial land, meaning thereby, my lord, they had already knew at a prior point of time that this land is going to be acquired because they have witnessed.
Oh, we are not into presumption.
No, well, I am not into presumption. Since that argument is forthcoming from their side, I have to reply, my lord. Therefore, that argument is forthcoming from their side. I have to reply. Now, they have to take resort of the 2015 Act, that is a self-contained code. And so far as Lordship's query is concerned, my lord, that section 6(3), it speaks of the 1894 Act. Now, in my respectful submission, even if we, my lord, for the timing, keep aside, my lord, section 3, then also 1964 Act is a self-contained code. 1964 Act is a self-contained code because it culminates in, the award culminates on publication of that gazette notification. Now, my lord, let us see, my lord, section 11, my lord, subsection 3. Section 11, subsection 3 of the 1964 Act.
Yes.
When the compensation has been determined, here the compensation has been determined under subsection 1 or section 2, of section 11, the collector shall make an award in accordance with the principles set forth in section 11 of the Land Acquisition Act 1894 so and so, but no amount referred to in so and so shall be included in the award. Now, section 11 subsection 3 speaks of the award. Now that award is a fallout of, my lord, section 6 notification. I need not trouble your lordship with all these facts. Now, section 12, reference.
Provisions of Requisition Act is upside down. Reverse to
I have to, my lord.
reverse to
because-
LA Act.
Yes, sometimes it so happen, my lord. It is very difficult to, my lord,
Here the chicken comes first and later.
because
In the
one,
other acts,
because
it comes first, chicken later.
Exactly what happened, your lordship is exactly.
No, we are not into virus.
No, by this,
No. We are not into that. I have said in a different context.
The major striking difference, because that is why, my lord, this issue of repugnancy has crept in. So therefore, this amendment, lordship has seen it. For getting out of the vices under Article 254, this has been incorporated. Now, my lord, reference, if they are aggrieved by any quantum, they can make a reference to the reference code. To that extent, my lord, I will be.
We'll leave it open so far.
Yes,
Classification
only-
is
only-
concerned. We'll not go into the merit because if they have done it, application, whatever, that will be considered by.
Yes.
If
to-
required to be relegated to reference code, we'll not discuss on merit.
Absolutely, my lord.
Right, so that if I find that it is not required to be discussed, I will not discuss. Otherwise, you will be prejudiced. If I find that
Now, the first is one, my lord, Amulya Mohan Das, collector of Kamrup. Here, my lord, same situation arose, my lord, with regard to reclassification of land. Acquisition was made for expansion of highway, paragraph 2, 3, 11 and 12.
2, 3.
2, 3, 11 and 12. Then, my lord, 13, 15, 16.
I'll read that.
Yes.
Okay. For Puja.
Their land was acquired, my lord, for laying down the broad gauge railway track from Jogighopa to Guwahati.
So they saw also.
Yes,
classification.
same kind of, my lord, agitation.
Okay.
Application was made. Then, my lord, finally it was referred. The matter was referred to by the collector to the referral court. Then this honorable court, my lord, came to the finding that it all depends on the factual circumstances and the evidences laid by the parties. Because it's a question of evidence. On record, we cannot, my lord, determine. He may say so many things, I may say so many things in my defense, my lord. Then, my lord, the second decision, my lord, this is of course an apex court decision, my lord. There I am relying, my lord, paragraph 5, 6, 9 and 10. My lord, yes, land acquisition officer, Tirupati versus P. Talai Reddy. Paragraph, my lord, 5, 6, 9 and 10.
9, 10.
This, so far as quantum is
6,
concerned,
5, 6, 9 and 10.
my lord, so far as quantum is concerned, my lord, it is out and out, my lord, exercise required to be done by the reference court, my lord. This is my respectful submission at this stage, my lord. And one but last submission, my lord, the fundamental striking distinction between the 1964 Act and the 2013 Act is that in 1964 Act, there is no scope for, my lord, raising any objection. Requisition, forceful possession, if required, then acquisition. No in between. But so far as the 13 Act is concerned, in every stage, my lord, the affected persons gets a, my lord, remedy to raise objections. I may raise an objection with regard to rehabilitation. I may raise an objection with regard to, my lord, environmental.
That is why Mr. Talura is seeking to throw it out.
One aspect just in between, I'm going on. Here the petitioners are resident of this. They are resident of other place. These are all. vacant.
Anyway, they are owner
Oh,
and position.
Rehabilitation, question of rehabilitation will not come.
So this is the striking difference because this act, we have done
Not
the
required to
exercise.
go beyond.
Yes.
Okay. Yes, anything add?
Yes, my lord. My lord, among
3
the-
minutes.
Yes,
One submission
my
is.
lord, kindly turn to page 87 ma'am,
Rehabilitation.
of my petition. 87, my lord. The
87.
latest Supreme Court judgment in this regard, my lord, covering
Okay.
all aspects. Thereafter, such, my lord, comprehensive judgment has not come so far as my knowledge is concerned, my lord. This is regarding, my lord, kindly it's the last line. I will start from the last line from page 87, my lord. Only, my lord, relevant part, my lord. Valid power of acquisition coupled with the provisions,
Page, paragraph?
page 87, my lord, of my petition.
Okay, read petition. It is, take me to the paragraph.
My lord, the last line, my lord, of page 87, my lord, of my petition. This is
Yes.
the, my lord, the valid power of acquisition coupled with the provisions of for fair compensation by itself would not complete and exhaust the power and process of acquisition. Prescription of the necessary procedures before depriving a person of his property is an integral part of the authority of law under Article 300A. And 352, the Act contemplates no procedure whatsoever. Thus, the exercise of the power of illegal illegitimate and cause great difficulty to the respondent land bearer, single judge held that appellant corporation acted in blatant violation of statutory provisions. Thereafter, I will go, my lord, held, my lord, the held part, my lord, below, my lord, next, my lord. Under the constitutional scheme, compliance with a fair procedure of law before depriving any person of his immovable property is well entrenched under Article 300A, which declares that no person shall be deprived of his property saved by authority of law, has been characterized both as a constitutional and also a human right twin conditions of the acquisition being for a public purpose and subjecting the investiture to the payment of compensation in lieu of acquisition were mandated. Although not explicitly contained in Article 300A, these twin requirements have been read in and inferred as necessary conditions for compulsory deprivation to afford protection to the individuals who are being divested of property. Furthermore, binary reading of the constitutional right to property must give way to more meaningful renditions, where the larger right to property is seen as comprising intersecting sub-rights, each with a distinct character but interconnected to constitute the whole. 7 such sub-rights can be defined, albeit non-exhaustive. There are the right to notice, the right to be heard, the right to a reasoned or decision, the duty to acquire only for public purpose, the right to restitution of a fair compensation, the right to an efficient and expeditious process, the right to conclusion. Thereafter, my lord, kindly turn to next page, page 89, my lord. There again held another issue, my lord. My lord. The prior notice held, my lord, prior notice informing the bearer of the right to the state intends to deprive them to the right to property is a right in itself. In a linear extension of the right to know embedded in Article 19(1)(a), Constitution does not contemplate acquisition by ambush, which happened to us, my lord. A notice to acquire must be clear, cogent, and meaningful. Of Land Acquisition Act, of the requisitioning acquisition of immobile property, the right to fair compensation and cutting act, my lord, the National Highway, sir. My lord, then, my lord, right to be
Same honorable judge has authored another judgment where he said presidential decision and non-presidential decision. When in a decision, a particular provision is discussed, then that judgment is to be considered in the context of that particular provision, not for any other provision, not even perimeter. So it is 352 Kolkata Municipal Act.
My lord, 300A.
7 days back, he has authored another judgment.
My lord, 300A, my lord, article, my lord. I'm speaking on the 300A, my lord.
That is in the context of Article 352 of the Kolkata Municipal Act along with 357.
My lord, 300A is explained details.
Anyway, I have seen.
My lord,
Anyway, I have seen.
any violation, my lord,
come
clearly.
to page 95.
My lord, any violation, my lord, clearly.
Come to page
said that-
95.
My lord,
Just above paragraph 2.
page 95, my lord.
4 line. 8 line. Sub-rights, 7 sub-rights. Right?
My lord.
And concluded his conclusion, not my conclusion. Page 95
Page 95, my lord.
of your petition, sir. The judgment.
Yes, my 94 perhaps, my lord.
Huh?
Yes,
Come
94.
to page 95.
My lord, this.
Just 8 line above paragraph 2.
Paragraph 2.
Okay, none.
Yes, my lord.
Okay.
Authority of law, my lord. Any violation.
Get
my lord,
the
is illegal.
notification. Okay. Who are present?
This
Take it, Talukdar.
argument, he should reserve it for the division bench because bias is not put to challenge.
My
Why
lord,
is it-
my lord, here at 300A, my lord, not other Kolkata Act, my lord.
Why
It's
should I
300A,
rebut?
my lord. It is elaborated, my lord, discussed in 300A, my lord. 300 is applicable for all, my lord.
Sir,
My lord.
for your knowledge, constitutional validity of the Assam Requisition Act has been upheld by the Supreme Court long back.
64 Act, my lord.
Requisition Act and provisions.
But perhaps, my lord, subject to your lordship, my lord,
Look into it,
300A.
look into it. I am not saying that.
Kindly have a look, my lord. 300A is, my lord.
Look into it. I have used the word precisely.
My lord,
Nothing
my-
more, nothing less.
My lord,
Hi,
brief, my lord.
Mr. A.K. Talukdar. I have given the whole second half to you. No more argument, please. Don't say that. No, what, Mr.? Right to hearing was denied to Mr. Talukdar.
No, my lord, given.
Petitioners. Mr. Borpuja, you're for whom?
My
You're
lord,
PWD.
No, my lord, I'm for respondent 5 and 6.
Okay, Mr. Nath. You're for PWD also. Okay, Mr. D. Nath. Senior government advocate. Assam, for the respondent number. Also PWD, I should say,
Yes, one,
and standing council, PWD. For the respondent number 1, 2, 3, 4,
7, 8,
7,
and 8.
8. Mr. R. Borpuzari. Standing council, revenue and disaster management department for the respondent number 5 and 6.
5 and 6, my lord.
Mr.
9. Airport
Up
authority.
to 7 and 8. This airport authority is a party.
Yes, my lord.
Order, এতিয়া order.
Contempt.
Contempt, ইয়াত কৰা নাই। Contempt, ইয়াত নহয়।
Oh, no. Somewhere I have seen something. We put it on day after tomorrow. We'll just get the order.
Both the get. 12 and
Hartel and council for the parties. Raise the case again on day after tomorrow as part of, but no more submission.
Absolutely. We are obliged, my lord.
Okay. Oh, Mr. JMA Chaudhary. এই order আসলে কি কালি যেটা দিছিল order দিছিল let him look into it. Where is Mr. Yesterday we disposed of.
Lordship will fix it tomorrow at 3 p.m. I think, madam.
No, his case is different. What is his case?
My lordship, I have raised a dispute under section 11 before the, my lord, before the.
Let him complete.
My lord, before the executive officer, that private respondent is not eligible to contest the election for the post of president.
Why?
Because she is not qualified under section 111(2)(b).
Educational qualification.
That is.
Then tomorrow.
Tomorrow.
Then, my lord,
Similar. Madam.
No, will held that the deputy commissioner has no power.
my lord, in my case, I'll show my lord, deputy commissioner has power.
Tomorrow at 3 p.m. together.
And
one case has already been fixed tomorrow at 3 p.m. You add then whether for 111-2,
Yes,
this authorities
yes,
like deputy commissioner
yes,
can decide.
yes. Because,
Defection, he can decide.
yes,
Then so far as
Three
two children or more than two or whatever, that he can decide.
yes.
Educational qualification, but the other person got elected.
With this, my lord, maintainability issue, my lord, this honorable court has already decided. I'll show my lord that.
When decided?
Decided in my lord 2002.
Let us have this opportunity because these are amendments of
Yes.
2000.
Yes, my lord, I've gone through.
Ah.
The provisions are same.
So that Mr. Dotto can also
Yes.
Yeah.
show it to, give the citation to Mr. Dotto also.
I'll give the 2002 11 AU, 2018.
Oh, there is Justice Ansari.
Yes, my lord. That judgment, my lord, covers my case. Because
I'll point out.
paragraph 58,
I'll point out.
paragraph 58,
57.
57.
Right.
Yes, 57 on what?
243 OB.
Yes,
Right.
yes.
Then there is a
120
reference of a judgment perhaps.
No, my lord, 127 and 129, that is also
No.
discussed. Yes,
In such situations, the citizens will be left with no remedy in
Yes.
law, which no civilized society claiming to be governed by rule of law can permit.
yes. If it is
Before
indirect
that-
election, if it is indirect election, then
Which one is indirect election, sir?
election of president is an indirect
No,
election.
no, which is your case?
My case is that, my lord, I am not on her membership, private respondent membership, my lord. I am limited to, I am a contestant of the president for the post of president. At the time of election of president, indirect election, I have objected to the, my lord, officer who was authorized to be present in the meeting. Then I have filed a representation before the deputy commissioner. saying
No,
that-
no. He is member.
Yes,
You are member,
yes,
right?
yes,
Then he got elected. You got elected.
yes.
Right.
Membership, I don't.
So it is not direct election,
Yes,
right? So it was a meeting.
yes.
It was a meeting held for selection of president, election,
of president.
election of president,
President.
right,
Yes,
right.
yes,
Now there you raise the question.
yes.
Good,
But Lordship kindly
But
say 100
challenging the validity of
good,
the.
good, good.
For that, my lord, 111, Lordship kindly say for a moment.
Good, good, good. I have understood.
Yes.
Tomorrow,
Yes.
raise the case tomorrow. I have understood. It is a case, his case is election.
My lord.
He has invoked section 11.
11,
Yes.
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 Which according to you
Yes.
should be 129B.
Yes,
Yes.
that is.
That-
Item
Okay,
5
then,
for orders.
not possible.
Because without challenging that, my lord.
Oh, yes, Mr. Talukdar. I forgot actually.
I can supply a copy.
I forgot.
Ablas.
Three queries, my lord. Since these are some old records has to be charged, my lord, they are asking for some 1 week's time.
Not before holiday. Because next week I'll not be available.
No,
And last week will be very difficult.
man. Item 7 and 8.
26, 2026 or calendar. Also. Let it be on 6th of January. Mr. B.J. Talukdar, Learned Counsel,
Inform
Senior
Kudu.
Counsel, listed by Mr. P.K. Medhi, Learned Counsel for the State Respondent, has submitted that the information sought for by this court are being looked into, and he would be in a position to place the same after 2 weeks. Full stop. as the informations are old, he'd be in a position to place the SIM after 2 weeks. First off, list the cases on 6/1/2026. Mr. Namtul Kilo, Mr. Emerson from Quadros. Mr. Swayze, huh? Kilo Namtul. Present. How? Yes, Miss Chakraborty, Sohan, not possible today. Item number?
5, I'm appearing.
Five.
Respondent.
Yes, Mr. Chauhan,
Actually, I'm
and you are
seeking
appearing
time.
for respondent.
Respondent, I'm seeking time in this case. for
Okay,
time
Mr. H.
to-
Chauhan, Learned Counsel for the petition is present, Miss P. Chakraborty. You are appearing for?
Water Resource Department. Respondent number 1.
Yeah, it is respond number 1, Learned Counsel. For the sole respondent. Has sought for. How much time?
4 weeks, ma'am.
4 weeks time.
This is the case
Earlier 2 weeks now.
Well, anyway, it will come after, anyway, I'm Lordship.
Okay, 3 weeks time. To obtain a necessary instruction and to file the counter affidavit full stop. The price law is the case after 3 weeks.
Obliged.
11 or anybody for 11?
You know, 11.
If there is no representative on behalf of the petition today on call. Petitioner and the respondents. Except Mr. A. Bhorasaizi, Learned Standing Counsel, Revenue Department. Others are absent. Okay, list the case after 3 weeks next year.